read the one for the warehouse burn video and just substitute the other clause for the closing video.
Which are you doing first? Which video?
Probably the burn video, the warehouse video.
Any position on whether I read it
No,
twice?
you can break
Okay.
it. That's fine.
Okay. Okay, so just remind me, counsel, to read that when you get to that point. And I'll read it for each video, and then we'll put it in our finals as well. I think it's a good idea to include it in finals.
Yeah, I agree.
I don't know that that's necessary.
Okay, we'll fight
Oh,
about
I
it.
will.
definitely
We'll
want
fight
to
about it
find
later
out,
then.
please.
Yeah.
So I guess jury's not here yet. Any other matters, and we can break until they get
I'll
here?
wait for Skip. I think Skip wanted to address something.
Okay. Okay, I'll break until he's here then.
Oh, should we wait for Skip on that?
Yeah.
Yeah, okay. That might be fine.
Counsel, I think we're still awaiting one juror. Was there a matter to address before the jury, Mr. Kelly?
No, I think we're good.
We're good? Okay. Did you want to talk about the juror issue?
Judge,
Yeah. Oh,
can I bring up one?
we're off the record.
Those as well.
Okay.
I think that's wholly reasonable, given that they're not, what they are.
Can you prepare that for me?
We just add it on to the others, that it's,
What do you want me to say? What is, if there's exemplar, what is the purpose of them being offered? There's exemplar sweatpants, apparently.
Correct.
What is the purpose if I give a limiting instruction?
Just he's gonna be able to say we're superior law at the same time.
So why doesn't someone else other than me or Joe prepare this for
No,
you,
that's fine.
counsel?
I don't have any problem
So
with that.
you two can work through how you want the wording before you introduce those.
Give us a few minutes.
Okay.
Talk to the
Yeah, let's talk to this chair.
I can do that when you're talking with your house.
okay.
To all the media in the courtroom, we need to speak to a juror. Please shut off all recording.
Skip and come back.
Well, if
Okay.
you want to work.
Please be seated.
Council, we're back on the record in the case of People versus Linda Stermer. Any matters to address before we bring in the jury?
Your Honor, Mr. Miller just had to run downstairs. I thought he'd be back, but if we could just wait just a few minutes, I'm sure he'll be coming in the door in just a few seconds.
Okay, thank you.
Thank you, Your Honor.
Bursting through the door.
Yeah. I think he just forgot something.
So, so counsel, on the sweatpant instruction, is this the final, the one you sent, Jay?
Yep, Wolf and I wrote that together, Your Honor.
You sure it's only 2 sentences?
It took us 10 minutes to fashion it.
Okay, the sweatpants you'll see in the video are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants. That's it? Okay. And you'll alert me when it's time to give that instruction, Mr. Mueller or Mr. Blair?
Yes.
Yes.
Okay. Okay, we'll bring in the jury. And Mr. Mueller, I think you had your witness on the stand.
Thank you. I'm recalling Robert Trinkle.
Morning. Sir, before you have a seat, I'll let you put your bag down, but before you have a seat, I'll swear you in again. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And Mr. Mueller, you may continue.
Thank you. Good morning, ladies and gentlemen.
One more thing.
What is the witness placing all over the bench? I see a bunch of binders coming out. What are those?
They have information, Mr. Leroy's photographs, things of that nature to refer to when I testify.
I would prefer, well, if they're going to be, are they even exhibits? I mean, we need to rely on either what's been admitted or.
Your Honor,
I understand that. I'm just kind of throwing that out there so we're all in.
Okay.
The back.
Sir, you can make them out for now, and we'll deal with it. If there's issues along the way, we'll deal with them as they come up.
thank you. May I begin? Thank you. Mr. Trinkle, yesterday we were talking about the scientific method at the end of the day. You remember that?
Yes.
And the steps you have to follow,
Yes.
and the consequences of if you don't follow those steps. You remember that?
Yes.
There's something that Mr. Leroy had testified to regarding a book called NFPA 921. Can you tell us what that is and what significance that book, that guide, has in the fire origin and cause industry?
NFPA 921 is listed as a guide for fire and explosion investigations on the front cover. It was first printed in 1992. The most current print is 2024. And it's a book that assists in how procedures in fire investigation, many of the other variables but that relate to and the periphery of fire investigation and direct fire investigation.
Okay. In a kind of a nutshell, does it give you the do's and don'ts of when you're doing a fire investigation?
That would be a good way of putting it. Yes.
Is that something that you've been trained on and fire investigators are trained on in the course of their careers?
Since 1992, I used that book as one of my texts when I taught in the college level, Medina University, a basic and advanced class. I used that book in Kirk's Fire Investigations as supplement.
Is NFPA 921 considered in the industry kind of the golden standard of the guidebook of how you train?
Yes, on the front of the book it says it's an ANSI approved document. It used to say it was an ANSI standard, American National Standards Institute standard, but a standard has to be in the form of shall, will, and must. It's codes. When I enforced codes in the fire inspection and fire department in Detroit, all the codes had to be met specifically. This can't be met specifically because there's too many other materials to cover, but NFPA 1033 is a standard, and it refers to this book as the book to follow.
Okay. I want to, as we now talk about your role in this case and what you did, I want to introduce subject matters, and you tell me if NFPA 921 guide you in those areas. I first want to talk about Mr. Leroy's excavation. Does NFPA 921 provide guidance in the importance of excavation?
Yes, it does.
And let me show you something. Is this a section 18.3.2.3 that discusses excavation and its importance?
Yes, it does.
Your Honor, I guess, are we admitting these as an exhibit?
No.
Since we're displaying them to the jury, or?
Again, under 707, it's a learned treatise that Mr. Leroy talked about, and it's used for impeachment of Mr. Leroy because it gives the guidelines that he didn't follow. Thank you. It's not going back as an exhibit. So let's talk about what this section says. Oops. One of these times it's a new pen. Adequate debris removal is essential for a thorough fire investigation. Do you agree with that?
Absolutely.
Why?
Why? Because if you don't do adequate debris removal, there's no way you can articulate the exact cause of the fire without clearing everything and making sure there isn't something else that you didn't uncover that could have been a cause.
Okay. Next part says, one of these times, there we go. Inadequate removal of debris and the resultant exposure of limited portions of fire patterns and other evidence may lead to an incorrect analysis. Do you agree with that?
Yes, I do.
That is everybody taught that?
Yes.
That would include Mr. Leroy.
I don't know what training he actually has. He should have had it, yes.
Okay. And then finally, a fire scene investigation normally involves dirty and strenuous work. Acceptance of this fact is essential in conducting a proper fire investigation. Do you agree with that?
I do.
Okay. You saw what Mr. Leroy said about how he excavated and his attempt to collect data.
Yes.
Does NFPA 921 speak to that?
Yes.
All the large print.
Avoiding presumption. Does NFPA, when we talk about avoiding, oh, what happened? When we talk about avoiding presumption, no specific hypothesis can be reasonably formed or tested until some data have been collected, right?
Correct.
Because how does that tie into the scientific method?
Well, scientific method says that you have to collect data, analyze the data, test your data, and formulate hypotheses. If you don't have all the data, how can you possibly do that?
In the second section, all hypotheses should be subject to rigorous testing through the scientific method. What do you understand to be rigorous testing?
Rigorous testing is, if you can, try to recreate what you believe happened and do it with physical evidence, deductive reasoning, recreate. So sometimes you can't, for sure. But if there's something that you can do, you want to make sure that you do everything you can to establish that it is right or wrong. You try to disprove whatever you believed it to happen. If you can't disprove that, and you have all these other potential hypotheses, if you can disprove, you can eliminate many of them and only have one you can't disprove, then you actually have a cause. But if you have more than one, you can't.
You heard Mr. Leroy testify. You sat in on his testimony, right?
I did.
And you actually read his transcript from his testimony.
I did.
All right. You heard him say you're trying to prove and disprove a hypothesis. Do you agree with that?
No.
Why not?
Well, simply because how can you prove and disprove to start with? You can't do both. If you do both in the same particular scenario, you're trying to collect data and analyze and come to a hypothesis. The idea is if you can't disprove it, then that must be a valid hypothesis.
And NFPA 921 speaks to whether trying to disprove or prove in the scientific method.
Yes.
Is this the section you're referring to, 19.6.4? When testing a hypothesis, the investigator should attempt to disprove rather than confirm the hypothesis.
That's correct.
And as we were talking about documentation and the importance of documentation, does NFPA 921 speak to that?
It does.
16.1.2,
Yes.
thorough and accurate documentation of the investigation is critical because compilation of factual data is necessary to support and verify investigative opinions and conclusions. How does that affect you in your role? You come in 15 years after a fire inspection, the evidence isn't there, the house isn't there anymore. What's the importance of documentation to you?
Well, it also says in NFPA 921 that when you conduct a fire scene investigation, you have to be able to preserve that investigation, whether you call somebody in before you do any movement and have that other person come in and look at it with you, or you photograph, videograph, diagram, and preserve it as you went along. Like, for example, to do the excavation of debris. You don't just take one picture before you move it and then one picture after. It's an archaeological dig, and you need to document and preserve every aspect of that. Every piece of evidence you find, whether it's of value or not, you have to record it so somebody else can take that same information and they evaluate it.
Okay. Now let's talk about what Mr. Leroy saw at his inspection. Do you recall, this is photograph 62 from Mr. Leroy's photographs. This is what would have been the basement that he said the first floor dropped into.
Yes.
Okay. And can you see the remnants of a basement fireplace?
I'm going to grab the pictures that correspond to that. I'm sorry for having to do this, but my eyesight's pretty good, but what I see in this picture is the some of the flue vents for the chimney chases.
That would be
I
this?
think that yes, and I think that is the fireplace right behind it.
And right here where I'm pointing, would that be the fireplace?
That's the fireplace for the basement.
In the
yes.
basement?
Yes.
Okay, so this is the 2 feet of rubble he was talking about throughout. Do you remember how big he said the living room was?
Yes.
About the size of this whole area of the courtroom?
Yes. I was at the scene, but there was nothing there. You know, I went there years later, so I know the dimensions, and I couldn't pinpoint obviously where a living room or any other rooms were, but I agree with that's approximately what it was, and we had diagrams to show that too.
Okay. And then you've seen Mr. McHugh's photographs that we showed?
I did.
I'm going to show you. What Mr. McHugh had said was the amount of excavation that, or documents of the living room. Again, it's all the rubble that was down there.
Yes.
Did you have any, do you remember when Mr. McHugh got there?
He was there on a day or so after the fire, I believe.
2
10th,
days?
maybe 11th.
Okay.
Well, actually, it's on his pictures. He
And
was
you
there
saw
twice.
Mr. Shinsky's photographs, correct?
Yes.
That would be the rear of the house after Mr. Leroy had been there
Yes,
and told us that he excavated a big pile that was 7 feet high. You remember that?
yes.
Okay. This is Mr. Shinsky's photograph. Did that play a factor into whether or not Mr. Leroy actually did what he said he did?
Well, it certainly confirmed he didn't. There was debris that he removed. He removed, obviously, the vent pipes that were central to that area, that space. And he also moved remnants of furniture, springs, and some debris. But even after that, yes, that's some of the, I think there's a vent, or the cap, and a few other things from one of the flues. There were triple flue there. There was one for the furnace, one each for the fireplaces. So there was a lot of piping there, and he removed some of it. But there are photographs that show after that there was still a bunch of debris, or that pictures that he even took himself to show there was a pile of debris still there.
I want to discuss some of Mr. Shinsky's photograph. Does Mr. Shinsky's, you reviewed his excavation and his photographs?
I did.
Does it comport more with what 921 calls for in terms of how you actually excavate something?
Yes.
All right, let me, if I can, Your Honor, we've admitted as Exhibit I the photographs of Mr. Shinsky. I'd just like to publish them as we go along. I know I brought enough for the whole class last week. I hope I have enough for the whole class this week.
Your Honor, can we please stop with the commentary?
This first photograph, what does this depict to you compared to what it would have been when Mr. Leroy left the place?
Well, this one certainly shows that they had an excavator or some mechanical equipment to help. But they take the walls down, and you can see them laying around the outside perimeter of the house. Twofold, one for safety, and the other to examine what the remains were. How sometimes they call it, if you just do it on a piece of paper, a blowout diagram. You put the walls on each side where you could, what's remaining, and you mark those as, wall north, south, and west, and east, and then show what's on the interior. Let's say it's for safety. It's for safety.
Let's talk about the second photograph. Does that show more of Mr. Shinsky and what he was doing in terms of taking the walls down?
Yes, it's a closer view, and now you see people inside where they now can feel safe. There's something not going to fall on them.
I'm showing you what was marked as Exhibit O, floor plan of the first floor. We can kind of get a reference. Do you see this back area? We'll talk about it more on other pictures. You see that back area that's cleared out?
Yes.
Does that correspond to where the bay window would have been?
From this angle, that's pretty much the best you can get, but yes, it's in the northwest corner of that room that you circled. That's probably better, yes.
Okay. And this is just more of an excavation as it's supposed to be done?
Yes. There's still debris on the floor within that room that Mr. Leroy is supposed to have
I'm on
excavator.
photograph number 5, and they're Bates numbered. We can see this excavator up at the top.
Yes.
Is an excavator appropriate for an excavation?
Yes, there's a variety of ways that you've got to be careful about using them, but absolutely.
Okay. As you look at the photograph on 5, can you see this man who's on the right over here?
I do.
All right, the area behind him, would that represent the living room?
Yes,
From the
that's the
basement?
area. That's the area that we're speaking of. That's in the darker color.
All right, so the bay window that's at the bottom would have already been knocked out by the excavators.
Yes.
So this represents the rubble on the first floor, which would have been the living room as it fell into the basement.
Yes.
All right. And do you remember what Mr. Leroy said about how he cleared out the basement?
He said he said he did it, but obviously he didn't.
Photograph 10 is just a photograph of what?
That's the electrical distribution panel that's obviously been involved in a fire with wires down below it that are bare copper conductors that have burned off.
Okay. Is that something you have to consider? We'll talk about it more in detail, but is that something you have to consider in terms of trying to find out what happened in the fire, what caused the fire?
Your Honor, when we approach,
I then want to talk to you about some of the photographs. This is 13 from Mr. Shinsky's photographs of the 15th. What does that show you?
That shows some of the debris that was removed, more than likely percent by excavator and placed according.
speculating is the number 75% by excavator. I don't think he's capable of saying that, Your Honor.
These are heavy pieces of evidence. A human being couldn't do it. He's been on thousands of excavations. Thousands. Thank you.
And others were moved by hand, the smaller objects.
Okay.
But in a placement such as they can look at them and define where they may have been and try to see what they may or may not have to do with the relationship of fire cause, or not only fire cause, but fire load.
More evidence of what?
Examining pieces of the appliance here to look at it to see if it could be ascertained whether there were something to do with the cause or just affected by the fire.
And in terms of laying it out and looking at the pieces individually, what step to the scientific method does that go to?
That would be, finding the evidence and then looking at it. You're collecting the data, which is that's some of the data, and then you're analyzing that data by putting it out and checking to see if you can make a hypothesis about each and every one of these pieces of equipment.
Okay. This last picture, 17. What does this show you in terms of how one excavates and the proper way to do something?
The investigator is isolating, for example, in this case, the flue pipes, laying them out, and I won't say in order, laying them out and seeing if they can determine a potential order, but as I said, there's 3 chimney chases, and you try to match up oxidation, different things on the flue pipes to see if you can match them all up, but some were smashed as a result of the collapse of the building. And then you've got other appliances again, furniture, that is examined and trying to determine what value they have, as I said, either cause, origin, or fire load.
In terms of fires, obviously every fire can be different. Big fires, small fires, dumpsters, whatever, right?
Right, they're all uniquely different, sometimes to a great degree and sometimes to a small degree.
Are there occasions, or frequent occasions, where the damage is just too much, where you have what's called a total burn?
Well, total burn is, like the word says, total. but a burn that is very extensive with collapse of floors, roofs, and all that is a very difficult investigation.
And why is that?
Because much of the items that have been consumed in the fire, much of it is because there is such a wide area that you can't even find the origin.
Does NFPA speak to that, NFPA 921?
It does.
Well, I'll show you this section, 18.8. Is that what you're talking about?
That's the one I have right in front of me, yes.
Yes?
Yes.
All right. What that document says is a conclusion of the origin investigation can be the identification of a volume of space too large to identify causal factors or no practical boundaries can be established around the volume of the origin, right?
Correct.
All you folks are taught that.
Yes.
You tested things like that,
Yes.
and I'm sure you've taught it to firefighters.
Yes.
Okay. In this particular case, Mr. Leroy defines an area of origin, as we had talked about 20 feet by 20 feet. Is that, in your opinion, a reasonable area of origin?
It is not,
Why not?
because as this section says in practical experience, the book talks about an area of origin and a point of origin. Sometimes you actually do have a point of origin, but most of the time you do have an area. But that area consists of a very much smaller diameter or perimeter.
Give us an example.
Fire starts in a living room. It consumes many of the contents in the living room, flashes over, but by examination of each piece of the evidence there, you can get down to maybe a sofa where somebody was carelessly smoking, or a lightweight electrical cord in the floor that may have been the cause of the fire. But you have to do that, as it says, painstakingly, hard and dirty.
Is there any sense of embarrassment if you say the area is too big, the damage is too much? I have to say it's undetermined where the fire started.
No.
Let's talk about the area of origin as one, the living room, and then two, you reviewed Mr. Leroy's work. Did he adequately consider alternate hypotheses in terms of the area of origin?
He did.
Why not?
I'm sorry, maybe I misunderstood the question.
Yes, did he adequately consider anything else other than the living room?
He didn't adequately, but he did consider other hypotheses.
Okay. Did you, as you looked at the file, see other areas of plausible origins of the fire?
I do.
Give me an example of one.
The most reasonable one is the fire in the chimney chase.
And we'll talk about that in
I think we're talking about cause, not area of origin.
no, we're talking about the area of origin of a fire in the chimney chase.
It all allows
Okay.
examination.
You have to get, thank you. Do you have to get to origin before you can get to a cause?
Yes,
Why?
because if you have the wrong origin, you couldn't possibly have the right cause.
Okay. In terms of analyzing the chimney chase, what did you look at?
I looked at photographs and actually Mr. Leroy's trial testimony in this case, where he said everything I would have said to say the chimney chase is the most probable cause, or possible cause. I won't say that. He had information that he said exactly like I would have said to say this is something that we have to consider.
Okay. Did you look at, for example, photographs of how the fire was spreading from the in-car video?
Yes.
And witness statements
Yes.
from the on-scene folks.
Yes.
I'm going to show you one of the prosecution's photographs from the in-car video, and what does that describe to you in looking at the house?
That's from a dash cam from one of the responding sheriff's officers, and the fire is in the back of the house, burning in the upper portions, and the smoke's coming out from that back central section.
Okay. Do you remember witness statements saying they saw flames coming through the roof?
Yes.
Okay, would that be consistent with the chimney chase fire?
Yes.
Did you also look at Mr. Leroy's pictures?
I did.
I'm going to show you a photograph, and you tell me if that helps give you evidence or data to consider in a chimney chase fire as another point of origin or area of origin.
Yes.
You tell me what we're looking at and where you want me to point.
If you can point toward the second or the first floor fireplace, which is almost dead central in the picture. Right
Here?
there. Yes.
I'll back that up. Go ahead.
Okay. The roof is collapsed behind there, behind the chimney, and there's almost nothing else left behind the fireplace where the chimney chase would be.
Tell us, what is a chimney chase?
Chimney chase is a facade that goes around the flue vents, and it's supposed to be a certain distance away from the flue vents. There's not supposed to be anything in direct contact, but that's what's directly behind that the chimney. In that opening where you've got the header and the vertical 2x4s, where Mr. Leroy said, well, that was proof that there was no fire in the fireplace. That really would have had nothing to do with it, because that is a protected area, and there would be no way that it wouldn't burn if everything else burned, except it was protected and it was insulated, and it was what held that fireplace in check. But I don't believe there was a fireplace fire. I believe if there was anything, it was in the chase, and nothing else above here except minuscule amount of rubble, and the chimney or the roof failed at that point, which is a good point of reference to find out where something happened.
What causes a chimney chase fire?
A variety of things. The flue vents now are circular. They're not just old brick and stuff like they used to be in
So you
ceramic.
saw the aluminum flues.
Yeah, they're not aluminum, but steel.
Steel.
Yeah, stainless steel usually. Some are just plain old.
So what can cause a fire to happen in a chimney chase?
All right, two
With the
things.
flue.
One would be having insulation directly in contact with it. I've had two fires, actually one was one way, one was the other, just within a couple months apart, a couple of years ago. One, because they were putting blown-in insulation in the roof area, and they were supposed to protect the area with a chimney chase, and they didn't. So while they were doing the insulation, it fell into the chase and was in direct contact. So over time, the insulation materials caught on fire, which caught the chase on fire, which caused the house to burn. But it wasn't nearly as bad as this. I mean, it was very clear that that was the cause. The other cause was the result of these flue vents are 4 feet long, or 3, whatever the distance is. I think usually 4 feet. Those look shorter to me in the picture, but they are connected. You twist and connect until you get up to the top, and then you put a cap on the top of that.
And that's why it's laid out to analyze whether that could be a cause.
Yes.
But you have a lot of damage to those.
Right, they're too damaged to be, like say, some were, the ones that Leroy took out, some of them were actually almost flattened. I think he even mentioned that in his report or in his testimony. And those you wouldn't be able to tell. But in the other instance, the chimney came down in whole. The whole thing was on the side of the house, and everything. What remains of the chase and the flue came down, so we were able to put it all together. And there was a gap where one was
Objection, Your Honor. He's never held any of this evidence. He can't talk about putting things together. How is he testifying to this?
Your Honor, he's an expert who's done thousands of investigations, and including chimney fires, and he's talking about how you go about analyzing the evidence, the data. This is part of the scientific method.
But he's talking about, we put this together. He's never
didn't say-
touched
he
any
didn't
of
say
this. How is he
we.
testifying?
I'll allow him to re-answer the question. I didn't
Yes.
hear what you heard, Mr. Blair, but
Thank
Mr.
you.
Miller?
Now, I want to show you, Mr. Trinkle,
Yes.
I want to show you Mr. Leroy's photographs, his own photograph of what he took out of the house.
Yes.
One, is this the piece that you're talking about that was flattened?
It may be. I'm sure there were more than one, but yeah.
And does this look like how a proper excavation would lay out evidence?
No.
So do you have an opinion of whether you can rule out a chimney fire, a chimney chase, as being the area of origin?
Yes.
What is that opinion?
You cannot.
And what does that say in terms of Mr. Leroy's conclusions as far as your ability to have confidence in them?
You can't have any confidence in them, but I was amazed when I heard him say, and then it's in his, in the transcript, that he explained everything I just explained, basically, and how that could happen.
And then rule it out with what? Any analysis?
He said it wasn't low enough. That might be misquoting, but it was up high, and he explained how the fire would travel upward in the chase from wherever the fault was. But he doesn't know where that fault was, nor do I.
If you had a chimney chase fire, could it explain a sudden burst of flame?
Absolutely.
How?
Well, the chimney chase is confined. It's burning what's inside, but it's eroding the OSB or whatever, siding they had on that chase, and it's going to eventually go to the other areas. That's where you see the whole house is burned down away in the backside of that where the chimney chase was.
Okay. Now let's talk about Mr. Leroy's opinions of causation, how the fire started. Does NFPA 921 give us guidance on that?
Yes.
I showed this to Mr. Leroy. The cause factors for a fire.
19.1.1?
Correct.
Okay.
The determination of a fire cause requires the identification of those factors that were necessary for the fire to have occurred. Those factors include the presence of a competent ignition source.
Your Honor, I'm going to object. I think he can maybe ask the witness to talk about it, but he's literally testifying from the book.
I'm not testifying, I'm just reading what this says. And I
It is
apologize,
getting
I should
to the
have
point
blacked
of
that.
testimony, so perhaps rephrase the question.
Tell us what 3 factors are necessary, required to have a fire cause.
Certainly the competent ignition source, the type and fuel first ignited, and what brought them together.
Okay. Does it also speak, NFPA 921, as to whether or not you can get away with less than all 3?
It says you can't.
19.4.4.1, does that speak to that?
Yes.
Can you read that?
I can, particularly it's in front of me. Even though I don't need glasses yet, it helps.
Can you read that to us?
It says, simply identifying a fuel or ignition source by itself does not and cannot describe how a fire came to be.
In other words, 1 and 2 by themselves don't count.
No.
We're going to talk about how Mr. Leroy got to his open flame and gasoline issues, but do you remember him testifying about number 3, step 3,
Yes.
and how he couldn't identify how the fire 1 and 2 got together?
I do recall that, yes.
Okay. What does that mean in terms of being able to identify how the fire started, the cause?
Means he can't, and he didn't.
What does that tell you in terms of your confidence in his opinion that he actually identified a cause of the fire?
Well, I guess if I put a percentage on it, it'd be 0.
Let's talk about Mr. Leroy's identification of the origin and being in the living room, but how he used Ms. Stermer's testimony to help solidify that basis. You remember him talking about that?
Yes.
Okay. What's the one thing that you found consistent in every one of Linda Stermer's statements?
She was downstairs, he was upstairs, or her husband was upstairs.
And then what happened?
She heard a sound, a scream, and ran from the basement upstairs and saw that the fire was in the living room.
Do you recall whether he agreed with me that you can't be in two places at one time?
He did.
And what does that tell us about Linda Stermer being in the place where Mr. Leroy thought the fire started at the time the fire started?
It would tell you that there's no way she could have been involved in setting a fire.
Objection, speculation, Your Honor.
Mr. Blair, could you please bring the emotion down?
Sorry.
Thank you.
That caught me off
You
guard.
have
I
an,
apologize.
yes, you have an objection, and what is your objection?
Speculating as to whether or not the defendant could have started the fire. You can't opinion
He testifying that she wasn't in the same place as Todd Stermer when the fire started.
I'm going to sustain that objection.
Okay. Do you recall Mr. Leroy agreeing with me you can't be in two places at one time?
Yes.
And that Mr. Stermer was by himself when he got caught on fire?
Yes.
Let's do a hypothesis. Here's a hypothesis. Linda Stermer was upstairs with Todd Stermer when the fire started. Do you have evidence that would support that or disagree with that?
Evidence to support it.
You have evidence that Linda Stermer was in the basement.
Yes.
So you can rule out the hypothesis that she was upstairs when the fire started,
Yes.
right? That's according to the data that you have, and that's the only consistent data you have, right?
Yes.
Do you remember that Mr. Leroy found that evidence to be reliable?
I do recall he did.
In terms of alternate theories, alternate hypotheses, is that important that you have to consider different theories?
Absolutely important.
Why?
If you don't consider all of the other potential theories, then you can't come and render an opinion that there's one and only one reason for this fire to have occurred.
Let's talk about this idea of gasoline on the sweatpants. And first of all, why don't we do this? Let's talk about fire propagation. Can you tell us what factors are involved in fire propagation? Because you understood that one of the things Mr. Leroy talked about was this was a fast fire.
Yes. I believe that definitions of different kinds of fires would be a friendly fire, a hostile fire. Friendly fires don't get out of control, don't hurt anybody. We enjoy them, fireplace or campfire or cooking. So, on the other hand, when you say a hostile fire or a fast fire, that connotes that you can tell the speed of a fire by looking at it or not considering anything else.
Does 921 give guidance on whether you should be considering that? Calling things fast, abnormally fast?
It does.
Section 23.7.2 speaks to that, doesn't it?
I think it's stuck in the middle. Excuse me. Yes.
And what does that say?
It says, what the investigator may consider as excessive, unnatural, or abnormal can only occur in an accidental, or can actually occur in an accidental fire, depending on the geometry of the space, the fuel characteristics, and the ventilation of the compartment.
Tell us a little bit about that, then I want to show a video that you made. But tell us about the factors that go into it: compartment, fuel load, ventilation.
Okay. A fire in a accidental scenario will start, it's called the incipient stage, a very small stage of the fire. It will progress from that point and continue to progress depending on the fuel load and the ventilation.
Ventilation is very important.
Yes.
And fuel, fuel, do we think of it as maybe gas, oil, that kind of thing? Is that what fuel is considered?
Sorry, I missed that. I apologize.
To a fire investigator, what is fuel?
Fuel is anything that burns. Anything in this room, almost everything will burn. You know, steel, even how they make cars and things by melting steel and reforming it. But in a situation like we're normally used to, wood products, plastic products, you know, cellulosic materials, and you know, flammable and volatile materials.
And when windows burst open in a fire, does that help fuel a fire?
It does.
Why?
Because now more air and oxygen is let in.
You have a video that you made, what year?
30 years ago, I think, 1993.
And what is that intended to demonstrate?
That was intended to demonstrate at that time a specific fire, but it also was intended to show how a fire without any kind of fuel, like liquid potential that can ignite, ignitable liquids they call it now, was not involved.
And what's intended to talk about in terms of fire propagation?
To show how heat and smoke rise, which is natural, and the fire will continue to burn until there's no more fuel left or no more oxygen or somebody extinguishes it.
Were you considering, too, the time duration of how quickly a fire can develop with just accidental cause?
Yes, there's all kind of national and other videos that show, you know, a fire can go to flash over from a natural fire in 2 minutes, 3 minutes.
Okay. Is it intended to demonstrate principles?
Yes.
Your Honor, move for the admission of Exhibit JJ, a demonstrative exhibit.
Mr. Blair?
Other than the limiting instruction I'm going to ask the court to give regarding this exhibit, I have no objection.
Okay, thank you. Do you want me to provide that instruction now, counsel? Okay. Jury, I have an instruction for you. This video is being admitted only to illustrate this witness's testimony. The parties agree that the video is not in any way a recreation of the events at issue in this trial. You may only consider this video to help you understand and evaluate the witness's testimony as it relates to the speed at which a fire might grow and propagate in the absence of liquid accelerants under certain conditions. Counsel
Thank you, Your Honor.
satisfied with that instruction?
That's fine.
Mr. Blair?
Yes, sir.
Okay, thank you. Yes, what,
JJ?
JJ? Court will receive Exhibit JJ into evidence.
And you can kind of describe for us as what we're seeing.
It's okay.
Yes.
Okay, right now, in that cardboard box, there's crumbled paper product. It was lit with a match. And there's nothing else to influence its growth outside of, you know, the configuration of the structure and the fuel load.
And you started at 2:04 p.m.?
You know, it says it on that one. I'm not sure the other, there are two camcorders videoing this, and I don't know if the other one says the same thing. I think it does, yes. We switch from this camera after about a minute to the camera on the other side.
Oh, jury, is this board in your way? Better? Okay, thank you.
This is just switching the cameras.
It was getting hot and they were moving it back, the camera.
You were actually present at this video?
Yes. It's burning a building inside my building. Probably not the smartest thing to do.
And what is this showing us right here when it hits the ceiling?
Heat and smoke, fire, go to the something that stops it from going straight up, a horizontal surface being the ceiling, and then it spreads out in all directions and continues to burn until the fuel is expended.
And this is in an enclosed space?
It's not totally enclosed. It's, as I said, I had a fire truck, and I had a fire truck, or I had a way to put the fire out, but it's in a big warehouse. My office, where my office was, had a 30-foot ceiling, so this is only an 8-foot ceiling. So we're not going to let it get beyond where it should. But to answer your question, there is sufficient fuel, sufficient oxygen to keep the fire going until we extinguished it.
And this is the speed of the fire?
Yes, and that's into 3 minutes, I think.
Right, that's only about 3 minutes into the fire?
Yes. And if everything was, all what it's going through is non-combustible, double-thick drywall. So we had plenty of time to let it burn and not have to worry about it going through into the rest of my building. We had 2 hallways to make it, so we had sufficient room for it to spread, and then the last one, where the last hallway goes right out to a 16-foot overhead commercial door.
That's only about 4 minutes in, 2:07?
Yes. And there's the firefighter's got his full gear on, including a Nomex headgear and a self-contained breathing apparatus. And when they pulled back, there was no fire anywhere near them. It was just a small fire, just to show you how convected and radiated heat transfer can give you some serious burns. So they were protected, and they got out before it got worse.
Okay. That's the end of that video. You illustrated that to show how fast fire can propagate even without any liquid accelerant or anything.
Yes.
Now, you also showed us, that fire is going pretty crazy in a few minutes. You've been in plenty of fires as a firefighter. Is it as dangerous as it gets?
Yes, that one's controlled, so everybody knew what was going to happen, and they knew there's no more fuel to ignite to hurt them. So, and they had fire hose lying right there from a fire truck. But when
let me address this. When you go through your training, is it so that you know how to act in a fire where
yes,
you're an inferno?
Yes, it's your job to put that out no matter what. People always think you see people running away and crazy firemen running in. You know, you have to know what you're doing to do that.
What are the things you're combating in terms of critical stress and the way the body reacts?
Well, certainly your heart's pumping more than it would normally. You know, you're excited and you are under a lot of stress because a lot of times we come to homes, we don't know if there's anybody in there. We always treat the fires as there is somebody there.
You've learned about critical stress factors that the body goes through,
I'm going to object, Your Honor. I think this is outside his area of expertise.
goes through its training as a firefighter. That's why they do repetitive training.
It's getting to be medical.
No?
If you stay away from any medical opinion, it's fine.
I'm not asking for opinions. You have received training on how the body reacts in critical stress situations, right?
Yes.
And those symptoms include what?
I'm going to object, Your Honor, that he's
Part of his
received training. It doesn't mean he's an expert on giving an opinion to a jury about what it might
Maybe
be.
lay more foundation of what
Sure.
the training was.
Tell us where your training was, what your training was, and what kind of subject matters you covered with respect to how a body might react in critical stress situations.
Well, the first 320 hours that we had were classroom training in all aspects of fire and, as you said, what we go through as a firefighter and to make sure we were able to cope with that.
And what are the things you're trying to cope with and fight against, which is how your training is going to help you?
Well, it's sort of like muscle memory when you're doing what you're doing and you do it over and over and over again, and you rely on the people you're working with to have that same feeling that you do. You know when you're going in with somebody, that we always said a thing called 2 in, 2 out, that we would go in together as a team. And if we were not coming out, both of us were not coming out. If we got out, both of us were going to get out. And so in that process, you know the things you're going to be dealing with. Back in my day, we didn't have self-contained breathing apparatuses, I shouldn't say in my day, in the beginning of my tenure.
Mr. Trenkel, with respect to critical stress symptoms, did you learn things like tunnel vision?
Yes.
To describe for us, please, the other body symptoms that you learned to prepare against with training.
Object as to relevance, Your Honor. I don't know how this is even relevant at this point.
Well, can I explain the relevance, since he made an objection?
I think, is it relating to Ms. Stermer? Is that?
Yes,
where you're going?
these folks train for critical stress. A middle-aged woman does not train for critical stress. That's how it's relevant.
We're providing facts into the record here. I'm just concerned about what's going on in front of the jury with some of these statements that are being made. But in addition, he's not an expert on critical stress. And how a layperson, he's a firefighter, he's talking about a firefighter, not how a layperson might perceive it.
It's based on his
How would you
training.
testify as to firefighters?
Yes.
And their stress levels and what he's learned through his training, but
Right.
not laypersons.
I didn't ask what a layperson, I just asked what symptoms have you understood through your training that you might go through that the training would help? You said tunnel vision.
Right. Well, make sure you maintain focus for sure, what you're doing, and not panic. I'm not sure the whole program that you're wanting me to tell you, but if you can maybe clarify.
Well, have you learned that you lose your fine motor skills?
Yes.
All right, that's why people fumble with their keys in a high stressful situation.
Yes.
It's leading and now it's
Thank you.
outside the scope. I'll sustain.
We'll go to something here. The gas on the sweatpants we were talking about. Under the scientific method, you remember that Mr. Leroy arrived on the scene 3 hours after,
Yes.
and that Mr. Stermer was at some point outside the house.
He was.
Do you have some understanding of how Mr. Stermer got from the house to where he was initially found and then transported?
From the house to where he was initially found, no. But from the movement afterward, yes.
And the movements afterward included, first of all, Mr. Matheny putting clothes on him.
Clothing being placed on him. Miss Stermer was on top of him, then she allowed Mr. Matheny, or not allowed, Mr. Matheny did put a bunch of things on him, but then there was also another movement.
And that other movement involved what?
I don't know if it was the fire chief or somebody else, there was somebody to assist to lift Mr. Stermer and put him into a little boat and then move him farther away from the actual burning building, because there was fear of there was a 220-gallon fuel oil tank right next to the house, and he wasn't too far from that, so they moved him away.
And as a fire origin and cause expert, you remember Mr. Leroy, 3 hours later, said he smelled gasoline?
Yes.
Or he smelled something fuel and it turned out to be positive gasoline on the sweatpants?
Yes.
Do you have to, as a scientific person under the scientific method, have to rule out how that gas could have gotten on the sweatpants?
Absolutely.
And one of the things you have to rule out is, was there, do you understand?
It's sustained, it's leading.
Okay, what one of the things are in terms of the boat transfer?
Objection leading, Your Honor, he's still leading the witness.
Ask you to ask non-leading questions.
I will.
Please direct.
Sir, tell us, if you're the fire origin and cause investigator, what you need to consider in terms of the transfer going back from where Mr. Leroy found him to the house.
I would have to consider, if anything, in that transfer of movement from where he was lying to where he was put in the boat and to where his final destination was, if there was any possibility of any other potential for a gasoline or fuel oil or any other kind of ignitable liquid to have gotten on him. You would have to take the boat, and we use things sometimes like sterile gauze and things like that to get liquid and then take that into evidence and have it go to the laboratory just to check to make sure there wasn't something else. And even on the ground, I would have checked the ground he was on. People are driving back and forth and all that. I don't know what was on the ground that might have been a contaminant. So those are things you need to think about.
What about talking to witnesses, family members?
Well, absolutely.
Did you find any evidence that Mr. Leroy did any of that?
He pretty much didn't talk to anybody.
Or wipe anything down?
No.
Am I right?
Correct.
All right. In your review of the evidence, did Mr. Leroy even consider collecting data for the boat?
According to what he testified to, he didn't even know a boat existed.
Okay, so according to the scientific method, if you don't collect the data, you can't go through all the other steps, right?
Correct.
And what does that do to your confidence level that he actually ruled out that particular alternate hypothesis?
Back to percentage zero.
Now, would you also have to consider maybe possible contamination?
Yes.
How would you consider that? And what are you talking about?
Well, we also know that Mr. Matheny placed clothing and other items on Mr. Leroy for a variety of reasons. He's pretty well naked in the ground and it's winter, and that Mr. Matheny had an occupation where he came into contact with flammable and ignitable liquids.
And what would you have to do in order to determine that maybe contamination caused it?
Well, if you were the person taking the evidence, each one should have been analyzed separately, but to compound the problem, these things were placed into the body bag together and were transported, and then each one were positive for slight residue of gasoline.
Objection. He can't testify as to what the level of residue was, Your Honor. He said slight. He can't do that.
I'll allow you to cross-examine on that point.
Thank you. You do know what the threshold that Mr. Ernst said the machine was?
Yes.
0.0005?
Correct.
4 zeros and 5.
Right.
All right. Now, one of the things that Mr. Leroy said he smelled the gas 3 hours before, do you have to consider and collect evidence about maybe what did people smell when they were the first people on the scene?
Yes, absolutely, and I think during the course of time he did find that out.
Did you see where he did not interview Mr. Matheny?
Yes, he did not.
And he didn't interview Ms. Calhoun?
He did not.
And he didn't interview Mr. Masali?
No.
All right. If they have testified in this trial that they didn't smell anything and they were the first three people there, would that be something you'd have to consider in terms of whether you could rule out maybe there was contamination, maybe there was something else?
That's why I talked to them.
Okay. And would you also then, well, let me ask you this. Mr. Leroy says it doesn't matter what they say. Is that appropriate?
Selective choice of who you want to interview and believe, I guess, I would say was wrong.
Okay. Does NFPA 921 speak to that in terms of confirmation bias?
Yes.
Tell us what confirmation bias is.
Confirmation bias is when you already have a preconceived idea that what happened and you want to confirm that with the evidence, and so it comes to fit your idea of what happened.
Okay. Confirmation bias described in NFPA 921, section 4.3.10. Can you read that for us?
Somehow we got things out of place. Maybe I can read it from up there. Confirmation bias occurs when the investigator relies exclusively on data that supports the hypotheses and fails to look for, ignores, or dismisses contradictory or non-supporting data.
And then it continues, does it not?
Failure to consider alternate or opposing hypotheses or prematurely discounting seemingly contradictory data without appropriate analysis can result in incorrect conclusions.
Okay.
Sorry it took me so long. Maybe I do need glasses.
Best, from the evidence that you have reviewed, does that fit into what Mr. Leroy did in terms of contradictory data?
He did not do anything to do that.
Would you say that that fits the definition of confirmation bias, what Mr. Leroy did?
Yes.
And what does that do for your confidence level in his opinion that the gasoline on the sweatpants related to the house as opposed to anything afterwards?
There is no confidence.
If there is a theory that Mr. Stermer was set on fire with gasoline, do you remember what Mr. Leroy said in terms of the evidence of any gasoline in the house?
He opined that through extrapolating the gas that was detected on his sweatpants confirmed there was gasoline inside the living room.
And what is that in terms of scientific certainty versus speculation?
All speculation.
And what is speculation in terms of an expert? Is that appropriate?
It is not.
Why not?
Sorry. Person who is doing a scientifically proper investigation is trying to disprove those different hypotheses, and there was nothing that Mr. Leroy did to show that there was an intentionally set incendiary fire.
And do you recall what he said where he admitted there's no evidence of gasoline in the house other than sweatpants on testing positive?
Yes.
Do you have experience, sir, in your vast career with what symptoms somebody might show if they were set on fire and inhaled gas,
Your Honor,
inhaled
he is
fire?
not a pathologist. He cannot give this opinion.
This isn't, I asked him for his experience with being a fire and origin and cause, attending autopsies, and having experience seeing people who've been caught on fire and what symptoms they exhibited on autopsy. That is absolutely within his background. It's based on his experience.
How a person may react when set on fire, he's not capable of doing that. He's not a pathologist, Jeff.
I'm not talking about,
He's a fire investigator, not somebody trained in human mechanics, dynamics, anything to do with pathology, how the human body, organ systems. There's just no way.
Your Honor, he has experience with autopsies, what he's observed for people in fire investigations where he has actually investigated people who have been caught on fire and inhaled fire and what that exhibits. That's based on his experience. He doesn't have to be a medical doctor. These are his observations.
I'm going to sustain the objection. I think it is outside the scope of his area of expertise.
The gasoline on the sweatpants, we talked about that and ruling out other things. Do you have, I think you didn't give us the opinion on whether that's reliable, that gasoline on the sweatpants has anything to do with this case.
I'm objecting, Your Honor. That's been asked and answered.
That hasn't been asked and answered.
How about we stop now and take our morning break?
How about an answer to the question?
It's been asked and answered, so we can move on when we get back. Okay, jury, remember your rules. Don't discussion of the case or looking at social media or media. Okay, counsel, jury has left. Any matters to address in the break?
None, Your Honor.
No? Okay, thank you. Back on the record in the case of People versus Linda Stermer, any matters to address before we bring in the jury?
Yes, Your Honor, can we approach to address it?
You may. Any other matters, counsel?
No, I don't think so, Your Honor.
Anything else, Mr. Blair, from your end?
No, Your Honor.
Welcome back, jury. And sir, you're reminded that you're still under oath.
Yes, Your Honor.
Thank you. Mr. Mueller?
Thank you. Mr. Treckle, I just wanted to make sure I summarize when we're talking about the excavation, just to put it a bow on it. Do you have an opinion whether Mr. Leroy did what he said he did?
Objection, asked and answered.
Your Honor, we're
That
summarizing.
you haven't already covered?
Just summarizing one point, that's all.
Why don't you be specific about what he did what?
In terms of the excavation, do you have an opinion that he actually did that?
Objection, asked and answered, Your Honor.
Summarizing it.
That part has been asked and answered.
I'm just summarizing, Your Honor.
Okay, we don't need the summary.
All right.
Thank you.
Mr. Leroy said in his testimony that gasoline can completely be burned up, which is why there's no evidence, zero, of gasoline in his area of origin, the living room. Is that possible?
Possible, but highly unlikely, but absolutely you can't say that because he didn't excavate, so how can he find if there was or was not gasoline there? There was no excavation, so there was no evidence taken and no analysis. You can't just arbitrarily say, well, gee, you must have been consumed in the fire when you didn't even try to find it.
Is there evidence in the rubble that you've seen that would suggest that if there was gasoline, it would have been found? Like in terms of how the material is and whatnot?
I say that it would or would not be is dependent upon the fact that somebody actually tried. I have not seen, if you do an excavation and you have other proofs or, data that suggests that there was an accelerant used, that you find it.
Let's talk about the gasoline on the 100% polyester sweatpants. First of all, just in order to set this up, I want you to look at that big binder there.
This one?
You did an examination of all the clothes in this case,
I did.
and you saw the clothes that was taken out of, you saw these silver cans and whatnot.
I did.
All right. I want you to look at Exhibit M. All the various pages, and just tell us if that represents the clothes in the package that you saw in your examination.
There are various packages and items that were placed into evidence, which I think they're in this room too, that were recovered. I actually saw most of them, I think, also. Well, I didn't see some of these.
Okay, but you saw the evidence and included the sweatpants?
Yes.
All right, move for the admission of Exhibit M. They represent what was presented to us at his inspection.
No objection.
Thank you.
Exhibit M. Did you say M as in mother? Okay.
Mary. Thank you. I want to have you take a look at a couple of the pictures from Exhibit M representing the sweatpants. Are those the sweatpants that you saw?
They appear to be.
Okay. And then this, did you have an understanding of the material that the sweatpants was made out of?
Yes, I do.
100% polyester?
Yes.
Okay. Did you obtain some 100% polyester sweatpants?
I did.
Okay. Did you run a video of a test of an exemplar
Yes.
with and without gasoline?
Yes.
Did you bring a pair of the exemplar 100% polyester sweatpants with you?
I did.
Can I show that to the jury? And I'd like to move for the admission of Exhibit Q.
They're in this bag. Don't we take them out?
I don't think that's,
As long as the court reads the cautionary instruction.
Thank you. You want me to read it now?
Yes,
or-
please.
Right, it's a good time to read it?
let me set up the foundation of the
Okay.
video. The video, you did a video showing ignition of 100% polyester sweatpants with and without gasoline.
Yes.
And how much gasoline did you use?
2 ounces.
Okay. What was it intended to show?
It's intended to show the difference between a fire that is accelerated in the presence of gasoline in the incipient stages. Well, it doesn't really ever have an incipient stage, to showing that with a match, our lighter polyester resists burning. If it does, it starts melting as opposed to burning.
Okay. You can go ahead and read the instruction, Your Honor.
Thank you. I will admit the video into
Yes,
evidence.
and let me just
first.
formally move for the admission of Exhibits R and S. R without the gasoline, S with the gasoline.
R and S, Mr. Blair, any objection then? I'm going to read the
No.
instruction. Okay. Jury, an instruction for you. This video is being admitted only to illustrate the witness's testimony. The parties agree that the video is not in any way a recreation of the events at issue in this trial. You may only consider this video to help you understand, well, I think there's two, right? 2 videos here. To help you understand and evaluate the witness's testimony as it relates to how polyester clothing might burn when doused with 2 ounces of gasoline versus how it might burn in the absence of any gasoline. Satisfied?
There was an instruction about the exemplar sweatpants as well.
We had one sentence.
Oh, that's the 2-sentence one. Did one of you, did you email it?
I did.
Okay, another instruction, jury. The sweatpants you will see in the video are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants, okay? Satisfied, counsel?
Thank you, Your Honor.
Okay, thank you.
We're going to show
I think we're admitting all
R and S.
R and S, and then M, he admitted.
Thank
Yeah,
you.
what happened to Q?
That's the sweatpants.
Q, yours.
Oh, Q, I'm sorry, yes,
Okay,
Q
Q
is
too.
the exemplar.
Okay, and you're good, Mr. Blair?
Yes.
Okay, we'll admit those.
I'm going to show exhibit R without the sweatpants first. Without the gasoline. Okay. Now I'm going to show exhibit S, and tell us what you did.
I took a 4-ounce metal measuring cup and I filled it half full with 2 ounces of gasoline. And then pants, same situation. And I threw it at it, backed up, and then threw a match.
Okay.
And ignited it. Can I make a comment, Your Honor?
Your
Well,
counsel.
I need the picture on there to do it.
You can illustrate what we're talking about.
Well, what I want to do is let the jury see the darkened color by the liquid and that see that that stays last thing to burn because it was still liquid.
And you can see it, what is it doing right now? It's burning and doing what?
And melting and falling to the ground. But I just want, you could see right in the beginning of the picture that when I threw the match, the liquid didn't ignite, everything around it ignited, and that's what I wanted them to see. That would be the first seconds of the video. And as it's continuing now, it's just dripping and burning, you know, because of the presence of the vapors of gasoline. Otherwise, it wouldn't do any of that.
You're showing the pants, but also is the waistband burning?
Yes, the one that's still hanging, you know, on the post. What is really starting to burn is the waistband because that's not polyester. It's a stretching material that is not polyester. So it keeps burning and keeps the other heat enough to have the pants still sort of stay lit.
Okay. Let's talk about Mr. Leroy's opinion that there was an open flame to gasoline, okay?
No. Okay.
Which was the open flame was what he considered an ignition source, remember that?
Yes.
And the gasoline, despite there being no gasoline in the area of origin, right?
Correct.
Okay. Does NFPA talk about that whole concept? First of all, there was no evidence, or did you find any evidence of an ignition source in anything he did?
No.
Okay. So what did he do, make one up?
With the evidence he had, he would have.
Speculation, Your Honor, make one up.
I'll sustain that objection. It calls for speculation.
If you're supplying an ignition source where there is no evidence of it, does NFPA 921 speak to that?
Yes.
Now, you said that gives guidance for everything that investigators are supposed to do?
Yes.
Yeah. First of all, let's look at 23.2.7.3. Can you read that?
23.2.7.3. It should be right next to the one I have, but I guess I'll do my best reading again. The investigators strongly cautioned against using subjective opinions to support his incendiary cause determination in the absence of physical evidence.
Okay. And 19.6.5 tells us
Identifying the ignition source for a fire by believing to have eliminated all ignition sources found, known, or suspected to have been present in the area of origin and for which no supporting evidence exists is referred to as negative corpus.
Okay. And then finally, negative corpus is defined in 4.3.6.1 of NFPA 921. And that tells us what?
Any hypothesis that is incapable of being tested, either physically or analytically, is an invalid hypothesis.
And?
A hypothesis developed based on absence of data is an example of a hypothesis that is incapable of being tested.
So NFPA guides us in that. And Mr. Leroy found no evidence of an ignition source, right?
He did not.
And why didn't he? In terms of excavation?
Well, he didn't do any excavation, so how can you find something if you don't look for it?
And a first fuel, can you tell us what first fuel ignited means?
Means the first Well, when we talk about fuel, it's fuel load. It doesn't have to be a flammable or combustible liquid. It could be your clothing, could be something that's not a hard piece of wood. Something has to have an ignition that can be a chain of ignitability to start burning everything else. But simple household furnishings and things like that.
Okay, so in simple terms, it's the first thing that catches fire?
Yes.
All right. Do you also have to, well, we talked about you have to tell us how the ignition source and the first thing that caught fire actually came together.
Sure, because there's all kind of ignition sources here and all kind of flammable or fuel, but you and I are all fuel, and if there's no ignition source and no, well, say there is an ignition source, say something is burning in this room, but you need to find out how that came together to burn one of us, basically.
Okay. And if you can't find all three things that we talked about, you have to determine, in terms of a cause, you have to say it's what?
It's undetermined. You can't, if you don't have any of those things or part of those things, how can you come to a definitive conclusion and say it is accidental and or incendiary?
And if you don't have a cause of a fire, can you classify a fire?
The only classification, it comes under classification, is undetermined.
Okay. Can you describe the 4 classifications for us?
I usually think there's only 3, but there's one that's called natural, which I always put as accidental, like the act of God, lightning, earthquake, things of that nature is a natural fire. Fire that's accidental obviously speaks for itself. A careless cook on a stove, any number of things that can be done accidentally without having an intent to do anything wrong. And the other one is an intentional act. An incendiary fire is an intentional act to cause a fire where it's not supposed to be caused.
And only one supports a crime?
Yes.
Would that be an incendiary fire?
Yes.
And given that Mr. Leroy didn't do the fundamental excavation to find the evidence, what level of trust do you put in any of his opinions?
Well, because things weren't done like they need to be done, no matter for what reason, you can't really then opine that you have anything but an unintentional or an undetermined fire. You can't say one way or the other whether it's accidental or incendiary if you don't do the job to finish what you need to do to get that information.
So, in your expert opinion, let's start with the origin, given that you said he didn't adequately consider the chimney chase for one. What trust do you have in his opinion that the living room is the area of origin?
I don't have any, because if the fire started in the chimney chase and then extended to the living room, there is no way of telling the difference because of the destruction of the property. It's too badly burned, and that hypothesis, particularly of the chimney chase, as I say, Mr. Leroy actually gave a whole page and a half of his definition how it would happen, but he says it couldn't by no other reason.
And now, how would you determine, forget the origin now, going to the cause, what classification is the only one that you could come to given the evidence in this case?
Certainly if you had no evidence of where the fire actually originated, it would certainly be even more so impossible to determine a cause. You cannot put a label on something that you're saying, well, how? And if you haven't got the answer to the first one, you certainly can't have the answer to the second one.
Okay. So that classification would only have to be
Undetermined.
all right. Do you place a lot of importance and weight on what classification you're going to give to a fire when you're doing your analysis?
Yes, absolutely.
Why?
Because what you're saying, particularly, well, in any circumstance, if you say the fire is accidental and it might affect another family member, and because you did something stupid, for example, you set a situation between people that aren't very good, and if you made a wrong determination even for that, you might cause family strife. If you call something incendiary, that is something that's so important to make sure you have the right call, because you alter people's lives, you change people's lives.
Objection, Your Honor, I don't think he can testify to this. This is well outside the scope of expert opinion.
He is an expert, and this is the kind of thing he considers when coming to a determination of classification, because there are ramifications. That's what he's testifying to.
Thank you. I think the jury understands that. I'm going to sustain the objection.
Let's talk about Mr. Leroy's causation issues with respect to time of day, two able-bodied people, and an abnormally fast fire. We talked about the abnormally fast fire, right?
Yes.
All right. Do you recall Mr. Leroy testifying in the course of this case that the cause of the fire was because of the time of the day and two able-bodied people were in the house, only one survived?
Yes, I recall that.
Can you show us 921, the book?
I can show you 921, but you're not going to find anything like that in the book.
Are you going to find that in any book?
No.
Are you going to find that with any credible source or authority in the fire investigation business?
None.
How about the idea of two able-bodied people? That was the time of day. Two able-bodied people. Do able-bodied people die in accidental fires?
Able-bodied people die in fires, get out of fires, but that is not anything to do with origin and causation of fire.
What is your opinion as to the quality of Mr. Leroy's opinion about that?
Well, he's totally in error, and he never learned that in school. If he did, we need a new school.
Let's talk about this red gas can that was found in the front yard the next day. Have you looked into that idea of somehow could it be related to this fire?
Yes.
I'm going to show you photograph 32 from Mr. Leroy's photographs admitted to one of the prosecution exhibits. You see this picture taken the night of the fire and that red gas can?
I don't know that I have that.
It's up on the screen.
Oh, I guess I don't have to look at it. Yes,
Okay.
I do recognize there was several pictures like that.
Tell us what impact all this firefighting equipment has on the possible location of that.
Objection, speculation.
No, he's been a firefighter. He knows when they drag hoses around. Thank you.
Well, when you can see in the photograph that the gas can is being encircled by hose lines, which are pretty heavy when they've got water in them. They don't just pop up. When you're dragging them around, they're dragging whatever might be in that perimeter. And so that gas can, I know, had been moved because
Objection, Your Honor. He can't say he knows it was moved.
There's been no foundation for that response, so unless he lays a foundation, I'll strike the response.
Okay. When you were a firefighter, do hoses stay in one spot or do they move around as you're dragging through the fire?
firefighters are moving the hose lines wherever they are necessary to try to extinguish the fire. And sometimes you have it in one location, you get the fire that you think controlled there, and you go to another avenue to try to put it out. If you look at the front of that house, there's holes cut by the firefighters to give them access to be able to put water into that house. And you'll see it all the way around the house. But so that line is being dragged around all over the place. And with the gas can being right in the middle of it, it's impossible for them not to move it.
Objection, Your Honor.
I'll sustain that objection and strike that response. Jury, don't consider the response, please.
Okay. The next day, Mr. Leroy showed the photograph. And do you recall, do we have that gas can here? Okay. That the spout was broken in two pieces?
Yes.
And the gas can was very muddy?
Yes.
All right. Do you recall or did Mr. Ernst, the MSP analyst testimony, affect your opinion on whether the red gas can had anything to do with this fire?
Yes.
What did you rely on in terms of Mr. Ernst?
Well, there was no liquid gas in that container. It was vapor. He takes and heats this, whatever he has, if it's a metal evidence container or if it's a nylon bag, he heats it up with a heated headspace and takes a syringe and pulls out a headspace and then analyzes it. There was, by his chromatograms and mass spectrometry, as I recall, he said that it was evaporated gasoline up to 85 to 95%. So that also is important.
And do you recall him describing it as the fumes representing old gas?
Yes.
Did that factor in?
Yes, that would be the case.
Okay. Do you recall what Mr. Leroy admitted as a fire expert as to whether the gas can had anything to do with this case?
He said he could not establish there was any link between the fire and that gas can.
Because there's no evidentiary basis for that?
Yes, correct.
And is that your opinion as well?
Yes.
Do you also recall what he said in terms when I asked him, well, if you were to have that opinion, you'd be speculating. You remember that?
Yes, and speculation, well, yes.
Go ahead.
I was going to, speculation is a guess. It has no evidentiary value.
And if you masquerade a guess as an expert opinion, what are you doing in terms of putting out your opinion as an expert?
No objection, Your Honor. I don't think that's a relevant question.
This absolutely ties into what Mr. Leroy admitted.
I think this goes more to argument, counsel so sustained.
Do you recall Mr. Leroy saying that would be misleading the jury?
Yes, that
Indeed.
would be misleading.
And do you recall Mr. Ernst saying that would be misleading the jury?
Yes.
Any opinion that is based on speculation would be misleading the jury?
Misleading whoever, the jury in this case.
Okay. Do you have an opinion? Mr. Leroy said that he complied with all the dictates of NFPA 921. Do you have an opinion whether that is true?
That he did?
Yes.
I have an opinion, yes.
What is your opinion to the jury?
My opinion that obviously he did not. We've come up to several different areas. We've explained that he did not follow or, because you claim to have done it, the evidence speaks for itself or the lack of evidence.
Okay. He claimed that he complied with all of the dictates of the scientific method which is required for your business. Do you have an opinion on whether he did that?
Yes.
What is that opinion?
Opinion he did not. Everything that you've had before you and everything that I've seen as a person following up on this case, there is the fact that he said he did an excavation, and there's photographs from Mr. Shinsky that shows that he did not. The fact
And
that
Mr. Shinsky's admission that he did the...
Oh yes, Mr. Shinsky said he did he did the excavation. We saw the heavy equipment out there and other people there helping in that excavation. And then the fact that Mr. Leroy doesn't have any photographs of that excavation, and he has nothing to prove that he had done it and everything to prove that he didn't.
So what does that suggest to you about Mr. Leroy's testimony about whether he did it?
Well, it's telling an untruth to you.
At this point, you're asking, going into the province of the jury as far
Okay.
as truth and falsehood.
Do you have an opinion as to whether Mr. Leroy adequately documented anything that he did in terms of collection of data, evidence?
Anything he did? No, he didn't.
And finally, as to any of Mr. Leroy's opinions, what is your level of confidence and trust?
I guess I'm going to object. I think we're starting to invade upon the
No,
province of the jury.
that's
now.
his opinion based as another
I'll allow
professional.
this one more time. My concern is cumulative, but
Okay.
I'll allow you. It sounds like this is the last question on the issue.
Go ahead.
Well, the fact that all these things have been presented to you, I have little or no confidence in his opinion.
Okay. Let me finish up a little bit here with, you and I have been doing this work now on this case since the end of 2018 when you met me,
Yes.
right? How many hours do you think you have in this case?
Upwards of 2,000?
Okay. And you've testified in criminal cases before
Yes.
on behalf of the prosecution
Yes.
and on behalf of the defense?
Yes.
And you've testified in civil cases on behalf of insureds, people who have insurance,
Yes.
and on behalf of insurance companies.
Yes.
So you, in every aspect, you've been retained and testified by both sides.
And sometimes third-party cases where it's subrogation, that one company says another company's at fault for causing a fire. Yeah, so that's not either side, I guess.
Okay. Let me just take one quick second. I'm going to return to this. Mr. Tranquil, have we covered all the subjects that you wanted to have covered in terms of what you were assigned to do and review?
Yeah, I believe you did.
Okay. In terms of Mr. Leroy's documentation of his work, were you hamstrung in any way?
Well,
You know, I guess I'm going to object. I think you already talked about the adequacy of the documentation, the questions have been asked and answered.
That hasn't been asked and answered, Your Honor. I can tell you that.
I'm not clear where you're going with it.
Just what affected the lack of documentation and the inadequate?
I'll allow it.
Thank you.
Overruled.
well, many times, coming after the fact, even, excuse me, when it's been years even, if there's adequate documentation, I could actually make a definitive opinion what may be the cause, either agreeing or not agreeing with the person, but actually coming up with a cause rather than me saying it was undetermined. So that's been the problem in this case.
Okay. But in any situation where you can't rule out different theories or ideas of what could have happened, where it could have started, what is your obligation as a fire expert to call it?
My obligation is to be truthful and call it undetermined. I can't tell.
And in this case, is the area of origin just too big because of the damage?
Objection, asked and answered, Your Honor.
Yeah, I'll
Okay.
sustain the objection.
I don't have any other questions for you. Thank you, Mr.
All right.
Trinkle.
Take that down to the,
I'm going to take everything down.
okay, good.
Yeah.
Black spot.
Excuse me.
Mr. Blair?
Thank you, Your Honor.
Thank you, Mr. Kelly.
Thank you, Mr. Kelly. Good afternoon, Mr. Trinkle.
Good afternoon.
I'd like to kind of circle back to something you said. You indicated you have 2,000 hours into this case. Is that correct?
Roughly, yes.
And you're billing for those hours, correct?
My billing is zero.
You're billing zero.
It's the same as all the other people working in this case.
So ordinarily, sir, you charge $225 per hour, correct?
That was my old fee. Now it's $275 for investigative and $350 for court testimony.
I understand. So you're not receiving any compensation at all for your opinion or to come here to testify today, is that
That's
correct?
correct. The whole crew of us are getting nothing.
Do you expect to receive something later?
No.
So you indicated that you received, you reviewed all the documentation in this case, is that correct?
All that I was provided.
Okay, what were you specifically provided?
Specifically, all the different, they're in the computer, most of my things. It was provided the initial fire report from Lawrence Township. I was provided the initial investigation report by Mr. Leroy. I was provided the report from Mr. Shinsky. All the statements under oath by Ms. Stermer. the information that was on recording by Mr. Shinsky of what Ms. Stermer had to say. Photographs, hundreds of photographs from all the responding personnel. In fact, probably most of the reports from, maybe all the reports, but I don't know. I got what I got. But from Maziowski and Ms. Rout and the lab reports, all those kinds of things. Plus, I conduct, well, you said what I was presented. I'm sure there's more.
Okay, fair enough. But my main point, I guess I'm going to get to, too, is you were provided the various statements of Linda Stermer, correct?
Yes,
And you reviewed those statements, correct?
I did.
And those statements, she would be considered, at least at the onset, an eyewitness in this matter, correct?
Yes,
And eyewitness statements, you're allowed to rely upon those according to NFPA 921, correct?
yes, you do.
And eyewitness statements are relevant, could be relevant in not only determining the area of origin of the fire, correct?
Yes,
And they could also be relevant in determining the cause of the fire. Is that also correct?
some instances, yes.
And you indicated during your direct testimony that to you an excavation means an archaeological dig, correct?
That's the way it's mostly described, depending on the depth of it. I think I also said that sometimes you don't have an archaeological dig because there's nothing really to dig through, and I think I said something like about a fire in a kitchen stove.
Well, I guess to get my point, NFPA 921 does not use the words archaeological dig anywhere in the text, does it?
They do not. Well, I don't think they do.
So when you say archaeological dig, that is your words and your definition, correct?
I would say that's the industry's definition by most people. If you want to try to describe what you're doing, what better way that you could describe it than saying, we have a pile of debris. We know the top part is probably the remains of the roof. The next one is their two-story building, the next floor, and the next floor. But in this particular case, it's the roof.
He's not answering my question.
I think it's,
But,
yeah.
and
I asked very simply, the use of the words archaeological dig, those are your words.
And then I replied, it is the industry's words also. We know by,
okay, that's good.
okay.
Thank you. And as a matter of fact, NFPA 921 uses the words adequate when it comes, or the word adequate when it comes to excavation. Is that correct?
If you have, yeah, well, it says inadequate, so I guess maybe adequate is something that they may say, but I think adequate could be misinterpreted. But
Fair, because adequate's a subjective term, isn't it correct, sir?
yes,
Or inadequate's a subjective term, correct?
exactly. One way, one the other way, yes.
Right, because if I was a fire investigator and I was reviewing potentially an excavation you did, I could come in and say, your excavation was inadequate, couldn't I?
Probably not behind me.
Well, that's not my question, sir. My question is, as a reviewing cause and origin expert, because of the subjective nature of the term, I could come in behind you and say, you did an inadequate job excavating, correct?
And if you did, you'd have to establish that I actually did an
Your
inadequate
Honor,
job.
can he please answer the question?
All right. It's kind of hard to answer yes or no to that question.
The last one, I think, was possible, so
Okay.
you may want to limit
Yeah,
your,
could you-
narrow your
could he repeat
questions, Mr. Blair. Yeah, we'll have him repeat.
You would agree with me that as I was a fire expert. I could come in behind your investigation, your excavation, and I could say it was done inadequately, correct?
I guess you could say that if it was you.
As a matter of fact, in this case, Mr. Leroy did do an excavation, correct?
He did move some things, yes.
Well, you saw the pictures from Mr. Shinsky, correct?
Yes.
Were you present here for his testimony in court?
I I don't think I did that. I think I saw that online.
So, would it surprise you to learn that the photograph Mr. Mueller showed you of the back of the Stermer residence with the various piles out back was taken by, you understand it was taken by Mr. Shinsky?
I'm not sure who took it. I know that it was different than, no, go ahead. I don't know who took it.
All right. Well, it was part of a packet of Mr. Shinsky's photos that were shown to you, correct?
I think it was, yes.
And would it surprise you to learn he testified that he took that photograph before he did any excavation?
Yes. No, it wouldn't surprise me. No, not at all. It would not surprise me.
Foundation, I'm not sure what photograph he's talking about.
I asked about the photo of the rear with showing piles of debris.
There are pre and post
I'll
excavation
overrule
pictures.
the objection as the witness has answered it and
Thank
seems to
you.
understand what he's talking about.
Okay, thank you.
Yes.
And so that would then indicate that Mr. Leroy did an excavation of the Stermer residence, correct?
Yes, there was obviously evidence, and I could even point out what I think he did dig through, but go ahead.
Okay, but your complaint is just with the adequacy of the excavation, correct?
I guess yes.
You guess yes or yes?
Well, I think I have to describe what I saw that was left that certainly would make it inadequate.
Again, my question, sir, is you take issue with the adequacy of his excavation, correct?
Yes.
You were also shown some photos of after the excavator hired by Mr. Shinsky had begun to remove parts of the residence, correct?
Yes.
And you were testifying, I believe, about how there was debris that was down, would be like in the basement level of the Stermer residence. Do you recall that testimony?
I commented there was debris, yes.
Okay. And you would agree with me that when an excavator is operating and removing things, things are falling into the residence as they're being broken loose by an excavator, correct?
Depending on the quality of the excavator. The excavator people I would hire would not let things fall back into the house.
Well, some of that may be out of their control, though, right?
That's why they take painstaking care in how they do what they do when they're not just moving debris around to throw it in a 40-yard dumpster and have it transferred somewhere.
Well, you would agree with me that if I grabbed a hold of a large chunk of, say, roof material or something with an excavator, as I'm lifting that back with an excavator, things might fall off, right?
They might.
You had opinion about the area of origin in this case. Do you recall those opinions?
Yes, they're multiple.
Okay. And you would agree with me that NFPA 921 does not contain any size specification for the area of origin, does it?
There is nothing that says it has to be 6 by, no, there is no, you're right.
So, for instance, an 18 by 18 living room could in fact be the area of origin, correct?
You would be correct maybe that it was the area of origin, but if you did nothing to limit that to a smaller area, I just never seen it happen before, I guess.
There's no requirement that you limit it to a smaller area, is there?
There is no requirement that says it, yes.
So this is just, again, your subjective opinion about what should be the area of origin, correct?
If you had a house fire like this, you might as well call the whole house an area of origin, even though we know there was no fire in the east and the south sections, if that's what you're going to say. In the industry
Your Honor,
standards.
I don't think this is responsive to my question.
Sir, why don't you
All right.
restate your question so he can be more
I'm
responsive?
sorry.
Okay.
Sir, what I'm asking you is, well, I kind of forgot my question. I'm sorry. Yeah, your opinion in this is subjective, that the area of origin must be narrower than the living room, correct?
Yes.
You indicated, I think, on direct that you determined or you believed the area of origin was the chimney chase. Is that correct?
I said it may be because I can't isolate that and this living room, and I believe the only reason that Mr. Leroy said it was the living room because he's got gasoline in it, and that limits him from having to worry about that. And he also said that in his testimony.
Well, let's talk about that, sir, because that's interesting. You said you could rely on eyewitness statements, correct?
You decide by the physical evidence if what someone
That's
is
not
telling.
again, Your Honor.
No,
that's
you
not my
rely
question.
on it,
I
but-
asked him if he could rely on eyewitness statements.
Sir, if you could,
In
that's a
part.
question you can answer yes or no.
In
if
part.
possible.
In part.
Okay. And you believe the statements of your client, Linda Stermer, correct?
That she was downstairs and
No, I'm not asking you for a recitation, sir. I'm asking you if you believe the statements of your client that you've reviewed.
Man, answer. He's answering the question. You can't cut the witness off.
You can re-ask the question.
Thank you. You believe the statements of your client, Linda Stermer, correct?
in part.
In part. Now, you reviewed where she said that she came up the stairs, correct?
Yes.
And you reviewed where she described that the fire extended from the master bedroom to the Todd's recliner chair, correct?
That's what she said.
And you reviewed would have been the diagram she would have drawn then in her examination under oath, correct?
I'm not sure about who drew what diagrams, but if she did one under oath, I mean, with Mr. Willison, I probably have reviewed it, but there were other diagrams that were made rough by a lot of people, so I can't really say which ones.
And you also would have read in her statement that she said it wasn't the fireplace, correct?
That's what she said.
And she indicated in her statement that there was no fire anywhere near the fireplace, correct?
That's what she said.
And that's an eyewitness statement, correct?
It's an eyewitness statement that you take at face value sometimes, and sometimes you don't. She's not a fire expert, so she wouldn't know what my thought process might have been.
Witness statements at face value. Let's talk about that since you brought that up. You brought up Mike and Connie Calhoun and Dr. Musali, correct?
Yes.
Now, you were a police officer for a period of time, correct?
I was a fire investigator lieutenant who had police powers. I carried a police badge from the Detroit Fire Department and the Detroit Police Department. I carried 2 badges.
And you, so you conducted interviews of witnesses then, correct?
All the time.
All the time. And you would agree with me that witnesses don't necessarily remember all details, correct?
That's one of the reasons you take it. And if it fits the patterns or the things that you know to be true with the physical evidence, that's how you differentiate one from the other.
Because based on your experience as an investigator and interviewing witnesses, sometimes the stress of an event can affect how they perceive things. Is that correct?
Absolutely, yes.
And it can affect the details they might remember, correct?
Yes.
Now let's cycle back to this chimney chase as the area of origin if we can. You indicated, I believe, that a fire would start in the chimney chase from either, I think you said the flue, or possibly an improperly connected chimney pipe. Is that fair? I'm summarizing, I understand.
Yeah, well, if I can explain a little bit.
Sure.
The description given by Mr. Leroy would fit almost exactly in part with what I would say. There is a breach somehow within the connections, or I think he described it as a hole. That could happen too, depending on the material that was being used and eroded through the course of time. Those kinds of things are a potential. I also said on direct, I believe, that there might be insulation too close to. The too close to the chimney chase can cause a fire over time. The fact that something escapes from the flue vent, and it's not that it was improperly, I guess maybe that's why I took exception to the improperly installed. It might have been properly installed, but because buildings shift and move and do things like that, I don't know how well those things were put together with a band to hold them, non-combustible band to the sides, which are combustible. So there's a variety of reasons why, that would happen. I think Mr. Leroy explained it very well, and he eliminated it because he said it would, wherever it happened, it would go up from that point to the top and burn everything out. Well, you've got a confined space, and heat is convected and radiated in that chamber also, and I know it's very possible that there was only OSB, from what I understand, on that wall. And so as that's being eroded or destroyed by the fire, it now is weakening the OSB, which is on fire, and that could have fallen into the living room and been the room of origin. Nothing going the other direction shows any sign, and Mr. Leroy very much covered that.
So it sounds like you agree with some of the findings of Scott Leroy, is that
Yes,
correct?
yes, absolutely.
Now, but you only seem to disagree with those that ultimately lead to this being an intentionally set fire.
No, I can't even say it wasn't intentionally set. In fact, I've testified in federal court to say I can't say it was not intentionally set. I said that the way that the investigators said this fire occurred is impossible to have happened. That's what I said.
And you've actually previously testified in this, right?
Yes, I just said in federal court, yes.
And you actually indicated at that time that it didn't look like it was a fireplace malfunction, correct?
At that time, I didn't have aerial photographs, and I didn't have a lot of the other photographs back in 2018 when that took place. 7 years hence, I have a lot more stuff.
What new stuff do you have?
New photographs, more photographs that I didn't have. I mean, they're not new today. They were new from 2018 when I testified. Now they're more new. And I'm not saying it was a chimney fire either. I'm telling you, we agree that there was something substantive in that chimney that needed to be looked at and needed to be eliminated. And my point is, we can't eliminate it.
Well, let me ask you some questions about this.
Sure.
Chimney chases, for lack of a better words, are like a long, tall box that's built around the pipes that go up through the roof. Is that kind of a
Right. In
way?
modern day times, yes. As I think Mr. Leroy also explained how the old chimneys were, brick
Correct.
and all that.
And we're dealing with a modern
Yes,
setup here.
absolutely,
Okay.
absolutely. So that's how it's built.
And the purpose of that is also to kind of keep if there is a fire, keep that fire kind of contained in one area. Is that correct?
It's supposed to. In this particular case, however, this chimney chase was built directly in the middle of the house. Most chimney chases are on the outside walls, so that's why I was able to tell causes of these things, because they were severely damaged and the remainder of the house wasn't, so we were able to conduct an examination that was enough to prove what happened, and I think there was...
Well, hold on, let me just stop. You're not proving what happened here, correct?
No. I'm just explaining that you're right. It's supposed to be, it is in a confined area, but it is not, in most cases, there are no fire-resistant materials in the chimney chase.
Fair. Now, as this, according to you, as we're describing this hypothetical chimney chase fire,
Yes,
materials are going to be actually falling down on top of the fireplace like Mr. Leroy described, correct?
yes,
And as a matter of fact, then, those are going to start to catch and burn not only the wall studs behind the fireplace, but also the header above the fireplace, correct?
You're speaking of the header that holds the fireplace in place?
Yes.
No, that's pretty well protected. That's on the outside. It's not even anywhere near where the grate and the fire is being propagated and goes up a chimney on an angle. It's called a throat. I had a diagram of one and how it's assembled. So, well, go ahead.
Let me ask it this way. Maybe I'm not being clear in my question. You saw the photograph that was up on the screen that was put up on one of Mr. Leroy's photographs showing the fireplace, correct? The first floor fireplace.
Yes.
And it had a wood header that went all the way around it, correct?
Header goes just above it.
Above it, I'm sorry. And there was framing around it as well still, correct?
I don't remember if I saw framing around the fireplace. I did see vertical studs going above the header.
And those are part of the chimney chase, correct?
They are.
And if a fire started in the chimney chase, the fire would then burn all of the fuel in that area, correct?
If it was not extinguished first, yes.
And we don't have it all burned in that area then, do we, sir?
We have a lot of damage, yes. By the fall down, there is certainly a lot of burning, but it did not consume what you're talking about.
So that would be an indicator then that it did not start in the chimney chase.
No, that header is on the outside. You're not looking at the interior, what was exposed eventually by the fire in the chimney chase or wherever in the building, forgetting where it was a chimney chase or not. That header was protected. You have everything else in that room, first floor and second floor level, burned to a great degree, much mass loss as it was described by Mr. Leroy, not about the chimney chase, but about how we describe things. Mass loss is the new word to say all the time rather than heavily charred, but in losing, okay, so what I'm saying is that particular board isn't burned and everything else is because it was protected.
Well, let me ask this, because it runs along the top of the fireplace, correct?
On the outside, yes. I mean, it's the outside base of what you're talking about to hold it together.
Can I pull up my list, Your Honor?
It's pretty empty here. You are so thoughtful.
This photo right here, sir, this is People's Exhibit 34-19. You've seen this before?
I'm sure I have, yes.
Okay. And that's the fireplace we're talking about, right?
Yes.
And that runs directly along the top of the fireplace, correct? That header?
Just like we said, yes.
Yep. And there's a backside to that board, correct?
Yes.
And that would have burned, correct? If fire had fallen on top of that fireplace?
You don't think the backside's burned?
I don't know. You're asking me a question, sir.
I am, because you're asking me, and you're showing a picture showing the front, and certainly I think I've seen aerial views that show that backside heavily charred.
But it's not burned all the way through, is it?
It's a pretty thick piece of wood, and it's not burned all the way through, correct?
Because if fire was burning in the chimney chase, when it lands on top of that fireplace, it's going to burn all the way through that board, isn't it?
No. It could, but normally, no. The fire's happening above, and you look at what the damage is above there, where OSB wood is no longer, and that would have fallen into the living room. That's the living room side.
But
This
the
side.
burning debris within the chimney chase would have fallen on top of that fireplace, correct?
Some would, for sure.
And then it would have ignited that board, correct?
Probably not. It did ignite if you look on the opposite side. If we show the opposite side, that board is heavily charred.
What I'm trying to get to is, sir, that board would have completely burned then.
And I would say you're absolutely wrong.
Oh, okay.
It might, but not in this condition.
You were asked about a little bit about gasoline, so I'll ask you the same question. And just so we lay a proper foundation, the vapors of gasoline are what burn, correct?
Correct.
And you would agree with me that if I were to, for instance, even in this room, pour gasoline here on the floor possibly, and put a candle over there, that those vapors could ignite, correct?
If the vapors got as high as the candle's flame, yes.
Okay. And in this case, we have a fireplace that's fairly close to ground level, fair?
Fairly close. You see that there's a bottom framing of that. So I mean, I can't tell from the picture, but 6 inches to 12 inches maybe. I could be wrong, but that's what it looks like to me.
And it is possible, is it not, to deposit an accelerant in a room, leave an open source of flame in a room, and leave that room, and the fire still ignite, correct?
You're asking me a hypothetical, right?
Yes, sir.
Okay, because I'm going to tell you about it depends. But yes, it could, depending.
And there are factors that depend on that, but it could happen, correct?
Could happen, but it depends.
Understand. It depends on probably, let me guess, the amount of gasoline and the type of ignition source, various factors, correct?
Well,
I'm just going to object here. We're asking questions, giving hypotheticals that have no basis in the evidence in this case. Zero. And it has to be based on evidence in the case.
I think it is, and I'll overrule.
okay. So, waiting for a question?
Did you do another?
I think he
You
answered the
said
question,
depends.
yeah.
He said yes, depends, so.
Yeah, you did, and that's fine.
Okay.
And you heard, and we already kind of went over this, Ms. Stermer's statements about the fire going from Todd's recliner to the master bedroom, correct?
I don't know if she said it was going. I mean, that was the depth and breadth of the fire, I guess. When you say going, it seems like you're suggesting it went from here to there.
That is what I'm at. The fire, she described a trail of fire going from the master bedroom or to his recliner or vice versa.
I guess I still don't understand. Are you saying she saw this trail here and then go there, or just saw this?
Just
wide,
saw a one continuous trail. How's that?
Wide range, yes.
Yes. In your expert opinion, that could be an accelerant trail, could it not?
Oh, I don't think anything she described would have been anything like a trail unless, as I said, if you're telling me you saw it go from here to here to here, that would be a trailer. But if you see an immense amount of fire going from a chair and including your husband in a wall, that doesn't tell me anything, except there was a fire in a wide area.
Let's talk about your the first video of the burning of the storage room. Is that right?
Yes, it was a storage room for a party store.
And that was actually a fire designed to replicate a other fire you were investigating.
Yes.
And we saw lots of cardboard boxes in that video. Is that correct?
Yes.
And they were started on the floor, correct?
Yes.
And then they were actually stacked up to the ceiling, correct? Or close.
Close.
Yeah.
Close, yes.
Close to the ceiling.
Yes.
Fair. And then there was also a shelf along the ceiling with more cardboard boxes on there, correct?
Yes, they were, yeah, just yes.
And that fire, those cardboard boxes are fuel, correct?
Yes.
And would you agree with me, and I understand this is a layman's way to describe it, but cardboard boxes are fairly easy to set on fire.
I was going to give you an example of what was on the top. They are not easily ignitable up on top. And cardboard, it all depends, I guess, again, but those cardboard boxes, you saw how long it took for the sides to burn and how long it took them to actually become involved in the fire. So they will readily ignite, but not in a fast format or the way they, I don't know what the word I wanted to use, But on the top, they're old, long neck boxes that carried 24 bottles of beer. They don't ignite very easily. They're very strong. They're more dense. They're more pressed together.
Well, you would agree with me, obviously, that cardboard burns much easier than, say, like a log of wood.
Absolutely. Okay. Absolutely.
And that fuel load that you created in that room was designed to direct the fire up to the ceiling, correct?
No, it was to simulate the conditions that were told me by the owner, and this was the third fire we did. We built that building 3 times because we believed this guy, but the evidence didn't look like, I mean, if we just took it at face value, we'd have said the guy set the fire. The third one came out almost identical to what he saw, like what Ms. Stermer may have seen, and how that fire progressed before the fire department arrived. That's what I was trying to do. I was trying to simulate and see if we could create something that made sense to us by what he told us. And he told us what the cardboard boxes were. He told us what was in the cardboard boxes and how he'd stacked them, and that's why we did it that way.
And you said these were 8-foot ceilings, correct?
Yes.
And at the very beginning of the video, it looks like there's a fire started in the cardboard box. Is that correct?
Yeah, that's correct.
What was used to start that?
A match.
A match. Any accelerant used?
No.
You would agree with me that accelerant could have increased the speed of that fire, correct?
In the incipient stages. You know, there's stages of fire under normal conditions. Nothing's normal when it's hostile, but say you light a fire in a fireplace, you're doing whatever you need to stack the wood up in a configuration, put paper under it to make it burn quickly. What happens with gasoline and fuels like that, I don't like the term ignitable liquids because you just told me earlier liquids don't burn. I was against that, and I tried to not get it to happen in NFPA 921. I like flammable, combustible, things that are defined by my background. But going back to what you're saying, yes, in the initial stages, that would have not just gone slowly. It would have blared up or flowed up quite quickly.
A sudden fire, correct?
Yeah, absolutely, yes.
And going back to the chimney fire, those fires generally tend to start slowly and build, correct?
Yes, you have to pyrolyze the wood that is, I shouldn't use that word, but you got to take the liquid out of a solid to make it gas, to make it burn. And when you do that, it takes time when you only got a small, say, not a spark, but a small ember that comes out. It takes time, and over time, some of that wood becomes more susceptible to ignition. That's, I guess, what a better way of saying it.
Sure. And like the old adage goes, there's usually, if there's smoke, there's fire. So we expect smoke before the fire, correct?
In most instances, yes.
And in a chimney fire, we would have, it would have been expected that there would have been some smoke before this erupts into a blaze, correct?
It would be correct, but the smoke would be going up and through the chimney. I mean, up through the chase.
Well, you understand that this wasn't 100% complete construction, correct?
I do.
And so high likelihood there maybe were some cracks or some seams, correct?
Yes.
And so smoke could have escaped from those, correct?
Supposedly there was OSB, which is 1/2 inch thick, 5/8 inch thick, and it's porous, but it's stuck together. It's chipped wood and stuff held together by glue.
Well, and I guess what I'm trying to get at here, if I can, is you took, were asked questions about there being 2 able-bodied persons in the residence, correct?
Yes.
And that this was, the time of day was about 3:30 in the afternoon, correct? Maybe a little before.
Yeah, 3:30 I think was the fire call.
Fair. And you would agree with me then that if a person, that is not necessarily a factor for the cause of the fire, but is something that should be considered by a fire investigator, the idea that there are 2 able-bodied persons in the home and the time of day, correct?
Yes, it's good to know, but it doesn't give you any evidence of a fire origin or a fire cause unless those people told you that, and Ms. Stermer was the only one who said she saw this fire in that location. So that would be the only person. But the first call at 3:30 or 3:31, the guy said the fire's coming out behind the chimney.
Well, but what I'm trying to get at here, sir, if this is a chimney fire, is a slow starting fire, correct?
Correct.
And there's going to be smoke, correct?
And smoke and heat rise, yes.
You would expect then an able-bodied person in the home, especially during the daylight hours, to notice that, correct?
You're,
Foundation, he's the one who's been making objections all morning yesterday, that how he would
What's the
expect
objection?
someone else-
Objection is foundation?
Yes.
Okay. Response?
I think as a fire expert and investigating all these fires he's talked about, I think he can opinion on this.
Overrule, allow it.
okay, well, I guess I can give an explanation like a hot air balloon. It goes up because there's heat in the balloon to go up. Heat and smoke rise. There had a fireplace, or I had a fire in that chimney, which obviously is emitting smoke also, and that heat and smoke is going to rise. So unless those people were outside, they were only going to see it coming through the chimney flue, or what they thought was the chimney flue. It wouldn't be coming into the house.
But as the fire debris begins to fall down with inside the chimney chase, they're going to notice it then, wouldn't they?
Chimney chase is still enclosed as far as the fireplace hearth is all enclosed. So there's going to be no indication of that until the fire breaks through that wall. And I'm saying, based on our hypotheses between us, where it started is where it's going to be the most damage. It's going to go up from there, but that location is going to be where that wall is breached and other things are coming down at the same time that's being breached.
There's actually a sound that's associated with chimney fires, isn't that correct?
Crackling sound of fire, they got a fire in the fireplace. There could be a sound, there's going to be a sound, but whether you detect it or not, I don't know.
Now, one other thing I wanted to point out, I'm going to circle back, I guess, to your video. I keep finding different avenues as I ask questions, I'm sorry.
That's okay.
Your video, the first one of the storage unit.
Yes.
That fire, you would agree with me, doesn't spread to the surrounding boxes for about 2.5 minutes, correct?
That's probably, yeah, about right. I mean, we both would watch the time and know for sure, but yeah, somewhere in that general time. It was not that quick and it wasn't that slow.
Were you actually inside the building?
Yes.
Okay, was that you filming?
No, my son was filming with another firefighter. These both were Detroit firefighters. They're both retired chiefs now. I'm getting old.
Fair. So what I'm getting to is, you could have escaped that fire if you had to, correct?
Yes.
And would have escaped without injury, correct?
Yes, unless I would have stayed where you saw the film kind of being jingling around. That's when the heat was too hot for those guys who even had fire gear on.
But of course, for that to have happened, you would have had to have sat there and watched this fire overtake you in the matter of 3 minutes or so. Is that correct?
Yeah, I mean, if you were able-bodied, you should be getting out.
And you were asked questions about gasoline in the area of origin, correct?
Yes.
And we know Todd Stermer had gasoline on his sweatpants, correct?
We know there was analysis from the chemist that said it was 85 to 95% evaporated gas.
Objection, Your Honor. I don't think the chemist ever said that about the sweatpants. Fair. But again, you indicated there was, let's just go this way, there was gasoline on the sweatpants, correct?
There was residue of vapors of gasoline. When you say gasoline, I think of liquid, but there was no liquid on his pants.
Fair. You don't know how much gasoline was ever on those sweatpants, correct?
No.
So when you say, when you throw 2 ounces on a pair of cut-off sweatpants on a video, you have no idea, that has no way bearing comparison on how much gasoline was on Mr. Stermer's sweatpants, correct?
In jury instruction, it was never intended to demonstrate that. He knows that.
I think it could be misleading, so I'll have you move on.
Fair. Let's talk about the sweatpants you have as an exemplar and the ones in the video. Those are those the same sweatpants you have there that were bought, that were on that video?
Yes.
Where were they purchased?
We bought 3 pair, and I preserved one, the gray one we burned. That was gray, I think, too. And the reason they were cut off is I did probably 20 other different kinds of demonstrations with them that we didn't admit.
And those are not the same sweatpants that are that were on Mr. Stermer, correct?
Same objection, Your Honor. This is misleading. We have a jury instruction, and he knows that.
I think this is perfectly relevant, Your Honor.
I'll allow it.
They're not the same.
They're not. They're not the same manufacturer, correct?
I don't know. No, they can't be. Well, I shouldn't say they can't be. One was made in Vietnam, and the other one was made in China. These were made in China. Stermers were made in Vietnam.
And you can't tell us they're the same thickness, correct?
I guess we could compare them.
No, I'm asking you. As part of
Oh,
your
as part- right
experiment,
now-
you didn't verify they're the same thickness, correct?
Well, I didn't have possession and never did have possession. I looked at the things with Mr. Zerzine.
But you had an opportunity to examine those sweatpants, correct?
I was able to examine them, and the attorney would not let me do one thing I wanted to do because she's saying it changed
Objection.
the evidence. Well,
Talking hearsay, so I'll have you stop.
because I'm the one that.
Pardon?
I'm the one that was there doing it.
Okay, thank you, but I'll have you stop here.
Okay,
now.
all right.
Thank you. You can't verify that they're the same weave, correct?
I can't.
And as a matter of fact, when it comes to polyester materials, there are actually different chemical makeups of polyester, correct?
The word poly probably says it.
So when it comes to 100% polyester, some may be different. One pair of 100% polyester sweatpants may be different from a different pair of 100% polyester sweatpants, correct?
Yes, yes.
And as far as affecting how things burn, you conducted that test out in the open, correct?
Correct.
They were not on a human analog such as commonly used are pigs?
Nope,
And they were open to the air, correct?
they were.
And there was a breeze blowing actually that day, correct?
There was.
You can see, and that also feeds into a fire, correct?
Usually, yes.
So the level of oxygen is important here, correct?
I don't think there was a deficiency of oxygen where Mr. Stermer was and or in this fire, so I don't see the difference, but the oxygen is present.
I'm just going to renew the objection. He's talking about now differences in ventilation versus this versus the test. It wasn't to recreate anything, it was to illustrate principles. These days now we're getting into trying to compare circumstances.
I get your point, but I think it's relevant to the purpose that we stated to this jury as for the offering of the polyester, so I'm going to allow it.
Thank you. And again, these were out in the open, correct?
Yes,
They were not on a person, correct?
correct.
And you would agree with me that if they're on a person, that could affect the level of oxygen that they're exposed to, correct?
Yeah, they're being exposed to more oxygen, interior and exterior, you're correct.
And as a matter of fact, that completely discounts any human interaction with the pants, correct?
Correct.
Because a human, if, for instance, lit on fire, might try to put that out with their hands, correct?
That would not be a bad idea.
So,
Yeah,
as a matter
correct.
of fact, I guess what I'm trying to get at is, your experiment, we'll call it, was done under the most ideal of conditions, correct?
No, I don't see it that way.
But it didn't take into account multiple variables that you needed to consider in this case, correct?
No.
You talked about Mr. Matheny's clothes, correct? You remember that?
Yes,
And transference, correct?
yes.
And you were present for the testimony of Troy Ernst?
I think I was, I've heard it, think I was on video too. I mean, not video, YouTube at the same time.
And you indicate, and you heard him testify that on the shirt of Mr. Matheny is where the lighter elements of gasoline were present, correct?
If the lighter elements of gasoline were present, I think you're misspeaking, but I can tell you then he would have the most. The gasoline would be most on his shirt.
Well, no, okay. You're not a chemist, correct?
Nope.
You're not a forensic scientist in the aspect of chemical analysis, correct?
No, but I understand lighter and medium and heavy, and when you say lighter, that has more gasoline still residue left than the other way around. I think you just misspoke, but that's okay.
All right, fair enough. What I'm trying to get at is you heard him say that it was more likely that the gasoline was transferred from the sweatpants, socks, and underwear of Todd Stermer to the shirt than vice versa.
I did hear that, yes.
Please. Break now. I'll have you report back to the jury room at 1:15, and please remember not to discuss the case with anyone. Counsel, the jury's left. Any matters to address in our break?
No, Your Honor.
No, Your Honor.
Anything, Mr. Mueller or Mr. Kelly? Okay. we'll be in. Counsel, any matters to address before we bring the jury back in?
I'm done.
Done, Your Honor.
Okay, we'll bring it. Good afternoon and welcome back. And sir, you're reminded you're still under oath.
Yes, Your Honor.
Thank you. And Mr. Blair, continued cross.
Thank you.
Mr. Trinkle, I want to talk to you about formulating a hypothesis, if I can.
Okay?
There is some common sense that's used in this, correct?
I would hope so.
Because, I mean, hypothetically speaking, and this is very hypothetical, an alien spacecraft could shoot a laser beam into a house. That could be a hypothesis, correct?
It would be wrong, but it would be a hypothesis.
Fair, and that's what I'm trying to get at. There are some hypotheses that are just automatically discounted because they're very illogical, correct?
Yes,
And not likely to have happened, correct?
correct.
So when we're talking about considering hypothesis, we're talking about what the investigator may consider to be a logical hypothesis, correct?
Correct.
Based on maybe the circumstances that they observe, correct?
Yes.
And is it fair to say that one investigator might look at the work of another investigator and maybe come up with different hypotheses? Is that correct?
That's correct. One of them would be wrong, if not both.
Well, and that's what I'm getting at is this is your work in this line of work, this fire investigator, it's subject to interpretation, correct?
To a point.
And so therefore, you may reach one conclusion on something and somebody else might reach a completely different conclusion, correct?
And as I said, if that's the case in something like this, either one is wrong or both are wrong.
And obviously, you're not reaching any conclusion here today, correct?
My conclusions are that I, with the information I have, cannot make a conclusion other than undetermined.
Fair. You were asked questions about the red gas can, correct?
Yes.
And You at one time were a government investigator working for the city of Detroit, correct?
I was.
And you were trained to collect evidence, right?
Yes.
And if you had gone to a fire scene and seen a gas can out in the front yard, you would have collected it too, wouldn't you?
I believe I would have, yes.
So you take no fault in the fact that Mr. Leroy collected that gas can, do you?
No.
Because that's data, correct? Or possible data?
Possible, and that's why you do it. You know, then you do the analysis and all the other things, but yes, you'd collect it.
And you were asked questions about there being an ignition source in the living room. Do you recall those questions?
Yes.
And there, in fact, was an ignition source in the living room, was there not?
Yes.
It was the fireplace, correct?
Yes.
Because we know there was a fire going in the fireplace, correct?
Yes.
And those are based on the statements of Ms. Stermer, correct?
Yes.
Were you aware that we heard testimony about the boat that was used to move Mr. Stermer yesterday?
Heard testimony. I've heard different bits of testimony. I'm not sure what you're referring to, however.
Fair. Did you hear the testimony of Trevor Stermer?
Trevor Stermer. I didn't know. I was in the conference room. I wasn't allowed to be in here for that.
Would it surprise you to learn that it was a 6-foot plastic boat?
No.
Would it surprise you to learn that it never had a gasoline engine on it?
Never had what, sir?
Foundation.
I think it's an appropriate question of impeachment, Your Honor. He's been talking about it, and we learned testimony yesterday that there was no gasoline engine on it.
The objection foundation is misrepresenting the testimony of Durban notes.
I'm not sure he is, so I will overrule the objection.
Your question again was?
Sure. It would surprise you to learn that there was never a gasoline engine on that boat.
I would have no way of knowing either way whether there wasn't or if there was.
And you've been doing fire investigations for about 52 years, is that right?
Let's see, 71, 29, 49, yes.
Yeah? All
Yes.
right. All right. And when you reach a conclusion in a fire case, okay, or a cause and origin determination, you're not making a legal conclusion, correct?
I know you've talked about legal and a couple other things. It would be my conclusion based on all the facts and evidence, and I would turn it over to a prosecutor or something, yes.
Very good. That's your opinion, correct?
If I say it, it's more than opinion. It's based on more than just opinion. Opinions anybody can have, and they're worthless sometimes. But no, if I say the fire is an arson, that fire is an arson. There is no opinion about it. It's the facts that are in evidence that prove that.
But someone could disagree with you on your conclusion, correct?
And one of us would be wrong.
Could be
In
you.
this case, it wouldn't be me.
Well, it could be you, though, correct?
No, because I have the evidence to substantiate my position.
Well, I'm not asking about this case, and we were talking in
No, I'm not
generality.
talking about this case either.
Okay, all right.
I thought we were talking
So-
about generality.
Sorry.
Yes,
Okay,
if you
thank
wouldn't
you.
mind not cutting the witness off.
So you're saying your conclusions are always right?
No, I make a lot of mistakes. The main mistake I make is that when I have 95% that I think it's an arson, and I don't have that other 5%, I'm wrong because I call it undetermined, but that's the only proper thing to do.
You've been involved in criminal prosecutions before?
Many.
You've been involved in other fire criminal cases, even not with the prosecution, correct?
Yes.
And there's been situations where you've determined a fire to be undetermined, but that did not stop a prosecution for arson, did it?
There was no case I've ever... Oh, I'm sorry.
The objection is foundation?
Foundation, no, you go ahead, I'll wait.
Yeah, I'll overrule that.
Okay. I've never been involved in a case where I said a fire was undetermined and it went to a court hearing, particularly in a criminal case. No.
You were retained as an expert in the People versus Clint Dunning, correct, sir?
I was.
And you determined that fire to be undetermined, correct?
I was trying to say more than that, but as the judge knows, I was ruled I couldn't say that, and there was no Daubert hearing or anything. But anyhow, it was an undetermined fire, yes, and I don't believe it was.
And yet, Mr. Dunning was still prosecuted and convicted of an arson-related fire. Isn't that correct, sir?
Objection, Your Honor. He wasn't on the side of the prosecution. He's mixing apples and oranges here.
No, I'm not.
Yes, absolutely.
I'm going to allow the prosecution question, but not the conviction question. I don't see the relevance to what some other jury on another case did to argue.
Well, I guess what I'm trying to get at is, because that was a response directly to his question of he's never been involved in a case where he was made it undetermined and then the person got prosecuted. Well, I think...
So you can ask about prosecution, but not about what a jury did.
And if he limits it to where he was on the prosecution side, that's different than he was a defendant.
I'll allow you to ask about the prosecution question, but not
Fair.
what the
Fair.
jury did.
So the bottom line is, Mr. Dunning was still prosecuted, correct?
He was prosecuted without an adequate defense, and he will be tried again, or he will be exonerated sometime in the future.
And that's your opinion, correct?
That would be my opinion.
You're not a
I
lawyer,
can't-
correct, sir?
No, that would be my opinion. I can't say that that's going to happen. I believe it will, that's all. But you're right.
That is your subjective belief, correct?
That would be true.
No further questions.
These last couple questions, sir, that you were asked, you were testifying for the defendant.
Yes,
You've never been involved in a case. You were in law enforcement for a long time, right?
yes,
And you've never been involved in a single case where you were the fire investigator, where you testified or had an opinion that it was undetermined, where there was ever a prosecution. Is that what you're telling us?
that's correct.
Because if there's no intentionally set fire, incendiary fire, there's no crime.
Objection, Your Honor. He can't, that's a legal opinion.
Yeah, that's argument. I'll sustain the objection.
Then you were asked questions about the gas can. You remember that? This
That's a
red
lot of
gas
questions,
can,
yes.
a lot of questions. And what you would have done, you don't fault Mr. Leroy for taking it, right?
Correct.
The next day, the day after the fire, right?
Yeah, it was a day later, but he said, I think on the stand, he didn't see it the first time, so
Would
you
you have
wouldn't take
done,
it if you didn't see it.
would you have done something more than he did? Would you have done something like check for fingerprints?
Probably not, because on those cans, it's almost impossible ever to get a fingerprint off those cans. They're
Remember
not
the-
smooth.
Remember the questions you were asked about the scientific method, and could different experts look at things, same data, same evidence, and come up with different conclusions? You remember that?
Yes,
The point of the scientific method is that you have reliability and reproducibility, isn't it?
yes,
Okay. So if somebody does a thorough, proper investigation, another expert looks at it, like a peer review, what should be the outcome?
that peer review should confirm whatever the first person did.
If it's done properly,
And if you have all the, the information that the first person had, yes.
like collected the data, the evidence.
Right, if the data isn't collected that you don't determine to be of any value, somebody else can't look at it and see if it was or wasn't of any value.
So under the scientific method, if it's done properly, you should come to the same conclusions. You would only come to a different conclusion if what?
If you didn't have the same data that was preserved, even if two investigators came to the scene at the same time.
I'm just talking about just a situation like this, where
yeah.
you don't get a chance, all you have is what the person did before you.
Yes, I or no one else would have had a chance to have the same information and data that Special Sergeant Leroy would have had.
So if it's done improperly, you might not come to the same conclusion. You come to a different conclusion.
Improperly or inadequately.
Okay.
Back to that word.
That ties in. Let's talk about adequacy. First things you were asked had to do with the definition of an adequate excavation. Remember that?
Yes, Yes.
Does adequate mean middle of the road?
No, I think adequate to me, and I didn't look it up in the dictionary, I would have if I had time or had a dictionary. I mean, it means enough. Adequate means enough. Whatever that enough may mean, it means it's what you need.
It certainly doesn't mean average.
No.
In your opinion, was there any excavation that Mr. Leroy did that could be deemed adequate by any standard in your field?
Well, if Mr. Leroy said he removed all the evidence, I saw that
Your Honor, I guess I'm going to object. I think he can give his opinion about what he believes, but not the entire field. I don't think he can speak for every cause and origin expert on the face of the earth.
You could
He's-
limit the question.
A limited question. You're certified by AIAA,
yes,
the NAIA.
yes,
You've taught for years.
yes,
You trained for years.
yes.
Is there any, in your experience, any type of organization that would suggest that what Mr. Leroy did with his excavation was adequate?
Objection, Your Honor. He can't speak for every organization. He can speak for himself.
I'll sustain the
Okay?
objection.
In your opinion, sir, did Mr. Leroy do anything close to an adequate investigation?
Anything close is very vague. I would say that NFPA 921, there's a photograph and some things you need to do, particularly in a fatal fire, about sifting debris. There was a grid search I don't know, I got it marked, but ultimately, I think we talk about it depends, you know.
Well, let me ask you this, sir. He testified he cleared the floor, 18 by 18. You remember that?
Yes.
Did you see any evidence that he did that?
I saw a space of maybe, I can't really tell you dimensions, 4 by 6 toward the fireplace that was cleared, and I saw other debris outside. But going back to my Laird's talk, because we have collapse of roof and flooring and everything, you'd have to get down to the floor, but he said he did it to the floor.
Did you see evidence that he cleared an 18-foot by 18-foot by 2-foot area of rubble, sir?
I did not.
Did you see any evidence of a 7-foot pile of rubble, 4 feet by 8 feet by 7 feet, that he said he did?
The cubic foot thing, how much we had for 18 by 18 by 2 or 3, if it comes to that, a 7-foot pile, no, I didn't see anything like that.
Now, you were asked a lot of questions about area of origin and the size of origin. NFPA 921 guides us on that, doesn't it?
Yes.
Ideally, you'd like to find a point of origin, am I right?
That's the goal.
And what happens as you get larger and larger and larger areas of origin? What happens to the reliability of your opinions?
The larger it is, and you can't confine it to something smaller, how can you actually say what occurred if you have that big of an area of origin? To say this is what the origin was and this was the cause.
I want to go back to Mr. Shinsky's photograph when you talked about, let's see if I can get this now. Mr. Shinsky's, oh, that's what it is. Photograph regarding the back of the house. Thank you, Ms. Heidi. I think that's it. Okay. Getting back to Mr. Shinsky's photograph of the house, you were given a lot of questions about the chimney chase, remember?
Yes.
Based on your review of the records, the drawings, everything, how high was that chimney chase?
It would have to be higher than the peak of what was covering that, those 2, 4, 6, 8 bay windows.
Okay. And these bay windows in the back of the house, what can you tell us about what would have happened to them if there was a fire in the living room?
If the fire was in the living room and originated in the living room, the fire takes the path of least resistance. It doesn't seek or look for or anything like that. It's an inanimate object, but it will take the path of least resistance. And with that in mind, those windows are going to be compromised, and the flames are going to come out where that oxygen is coming in. And if it started there, all of that should be burned away. That shouldn't be standing there anymore.
Because fire goes up?
Yes.
And also, if we're talking about, you said there was OSB board, the testimony has been a lot of wood, open wood in the house, and around the chimney chase, OSB board.
Yes.
If that is up there, and we're talking about 2 stories, how is it going to fall into the living room?
Well, again, where it actually started, which none of us know, where that fault, if that's what the cause was. We don't know the level of that height where it was, but if it was still in the confines of the cathedral ceiling, it would fall inside the living room. If it was above that, it's going to fail and fall on the roof, basically, and cause a fire up there.
And you're not here to tell this jury definitively, based on everything you could find, that the chimney chase is the area of origin, are you?
Correct. No, I'm not saying that's what happened. I'm saying that was a very strong possibility, but I could not say it was.
And it's a strong possibility that has to be ruled out by the fire investigator?
Yes.
And did he?
No. Well, he ruled it out, but he didn't have evidence to rule it out.
Okay.
Okay.
All right. So, under the scientific method, what you folks always use, you have to rule out these alternate probabilities, possibilities, right?
Right. You have to be able to disprove everything else except your final hypotheses.
Right. Now, let me ask you about possibilities. Since Mr. Blair asked you about, is it possible somebody could pour gas on somebody in the living room and then run down the stairs? You remember that?
I do.
Experts, do you deal in possibilities?
No, that's so much of guesswork that it doesn't apply to anything as far as science goes.
You deal in evidence and probabilities?
Probabilities, yes.
Okay. Then you were also asked, well, why didn't you use a human being for those sweatpant tests, or an animal? You remember that?
I do.
And why didn't you use a human being for a sweatpants test, or an animal like a pig or whatever else he said?
There's this anthropologist doctor in California, and I wanted to set up, because she burns bodies and for a variety of reasons, but she's an anthropologist, so she burns them too much. And I wanted her to do an experiment for this, and she would, but she was already tied up to doing all these burns for an anthropologist, like bones. They were down to nothing. So I tried to get a cadaver somewhere else. All those things failed, so I couldn't do that. But the mere fact that I know what's going to happen to a body when you pour gasoline on anything.
Objection, Your Honor. He's testifying things this court's already ruled he
Yeah,
cannot
Your Honor,
testify to.
please, there's a legal objection in here somewhere.
It's irrelevant.
There.
It's outside the scope of
I'll
his
sustain the objection on
Thank you.
relevance.
Why didn't you use a live body like Mr. Blair suggested?
The live body would have gotten hurt or killed.
And it's unethical?
That would be a good reason, yeah.
Oh, you were also asked about some questions about polyester and difference in polyester. First of all, you understand, you do understand polyester is a man-made synthetic
It is,
plastic,
yes.
so it doesn't matter what kind of little blend of polyester it is.
Correct,
Polyester melts.
yes,
And that's what you're trying to illustrate in that video?
yes.
Okay. Give me 1 second, Your Honor. I think I might be finished. aware that Mr. Shinsky has a lot of expertise in fire investigation, origin, and cause,
Yes,
as do you.
yes.
Are you aware of any expert in this case, other than Mr. Leroy, who said that what Mr. Leroy did was adequate?
I'm going to object, Your Honor. That's going for hearsay.
If he's aware, I didn't ask for a statement.
I don't understand the question, honestly. What
Are
is
you
it?
aware of any evidence that any expert in this case besides Mr. Leroy defended what Mr. Leroy did?
I'm not aware of any evidence.
What was your answer?
I'm not aware of any evidence to that.
Okay.
All right. Thank you.
Thank you. Mr. Blair?
You would agree with me, sir, that that cause and origin investigation is not a, like, quote-unquote, hard science. Would you agree with me there?
What do you mean by hard?
Well, that's a bad question. Let me rephrase that. Like, for instance, a chemist in a lab or a DNA expert working in a forensics lab that rely on very controlled environments, scientific instruments, etc.
Yes,
So you would agree with me that that cause and origin is not a hard science?
there are variables that are uncontrollable, yes.
Because a lot of this relies on your training and experience, correct?
Correct.
And it's your interpretation of fire patterns, is that correct?
Fire patterns are being more and more discounted unless you have them covered with gasoline or some accelerant well, it depends what patterns you're talking about. I misspoke.
That's okay. That's all right. I'm asking in very general sense. It's you looking at something and then evaluating it based on your training and experience, correct?
Correct.
It's not something that you bring out a special instrument and it measures it and it gives you a answer within a reasonable degree of scientific certainty, correct?
No, we don't have that yet.
All right. Would you agree with me that a person that would have the opportunity to go to the scene and view the scene in its original condition would have kind of a better idea of what went on?
I guess I have to use,
Objection foundation and call from the speculator, we're talking about would have a better opportunity, that'd be one thing.
I'll overrule the objection.
it depends is what I was going to say, and then I will explain it depends. It depends on the level of experience of the one person as opposed to another, and it more depends on the first person preserving the evidence for someone else to see.
You would agree that being able to view something with your eyes in person is better than looking at photographs, correct?
Absolutely, but that can't be done in fire investigations because you're moving debris and changing the aspects of the scene as a way to get to the cause of the fire, and that's why you have to document it.
And just one final question, and just so we have a foundation here, you again reviewed Linda Stermer's statements, correct?
During the course of my 12 years involved in this, yes.
And you reviewed her statement that she stated that the only place she saw fire was between Todd's recliner and the master bedroom, correct?
I guess the word between again means it wasn't on either one of those things, it was between them, but if you want to say the expanse of the fire, yes.
In other words, she observed a trail of fire between the master bedroom and the living room and the recliner, correct?
I believe I answered that a long time ago, saying a trail is a whole different subject and a whole different observance or perception of a fire that is burning in all of those locations. There's nothing to do with the trail.
Nothing further, Your Honor. Oh, I'm sorry, hold on, Your Honor.
Mr. Mueller, briefly.
Two or three more questions. Person your experience, person of Mr. Shinsky's experience, even Mr. Leroy's experience, very hard to fool somebody like you into thinking that an intentional fire is an accidental fire, right?
Objection, Your Honor, form of question.
I'll sustain it.
There are obvious signs when some, I apologize.
It's sustained.
Thank you. There are obvious signs when somebody is trying to intentionally start a fire, right?
Objection, Your Honor, calls for, well, it's a very broad answer, it calls for speculation.
He's got 50 years.
The way it's phrased, I'll sustain on speculation.
Okay. Can you tell us the kind of, you mentioned trailers. Explain for the judge what a trailer is.
A trailer
For the jury.
Yes, observing a trailer. There was more of that years ago than there are now, but people would pour gasoline. I think that Mr. Blair actually said, you know, if you walked in this room and somebody poured a trail and set it on fire, you would very clearly see it visually if the fire flashed and went out. I think I remember Mr. Leroy was asked about a flash fire before too. And it's very obvious to see, and you'll smell the gasoline and you'll see this pattern. But it doesn't conform to the question I was asked and what Ms. Stermer saw.
Okay. A trailer would be obvious as opposed to should there was gas within a boundary.
Well, trailer can also,
I mean, strike that, not gas, a fire within a boundary versus a trailer.
right, exactly. And a trailer is a whole different meaning by me in all the years and way before 921. It clearly shows whether it was more masked by a flashover or whatever the case may be. The whole room may be involved, but hypothetically and sometimes often, when you go through the debris, you'll find this pattern, which is called a trailer. But the question I've been asking is not anything to do with a trail or a trailer.
There were no evidence of a trailer in this case, was there?
No.
No evidence of multiple points of origin in this case,
No.
which is another sign
Yes.
that might suggest arson.
Yes, if a fire was over here in this corner and a fire over in that corner with no reason for either one of them to happen, and they weren't communicated one to another, it'd be clear to all of us that that was something wrong.
Okay. And then finally, your ability to determine whether somebody did a job properly is based, one, on, you said, their competence and experience,
Yes.
and also, would it be based on their candor and truthfulness in what they did?
Yes, I always liken fire investigation to a chef. You're only as good as your last meal. Wolfgang Puck may have made a million good meals, and, as Mr. Leroy, but this case wasn't sufficient. Wasn't done sufficiently.
I don't have anything else. Thank you.
Obviously, in this case, we can't verify any trailer or anything in the living room because it was completely destroyed, correct?
The floor was, yeah, it was OSB. It went down below. Whatever was below, you might find the remnants of a ignitable liquid, but you wouldn't find the trailer, correct?
Well, there is certain factors that can determine whether or not you're going to find an ignitable liquid, correct?
Yeah, it depends on the degree of damage.
Right. So if the floor was completely destroyed and burned away, that could be a factor, correct?
Well, when you say it was completely burned away, there's residual debris on the floor. Yes, a lot of it was consumed and fell. The condition of how much was left is something I'll never know.
And another factor that could affect gasoline would actually be the amount of water used by a fire department, correct?
Gasoline is not water soluble. I've had cases where, well, I've actually did demonstrations where I could put 1,000 gallons of water on 3 ounces of gasoline on the ground, and the gasoline would stay on top, just like when you have oil slicks or slicks like that with petroleum distillate. They're going to remain there, and the water's going to go past it. It could push it around, but it's not going to change its components.
Well, that's my point. What you just described sounds like a controlled experiment where it was on a standing body of water, correct?
No, I'm saying that I poured the gasoline, and I found gasoline when 500,000 gallons of water had been applied to a fire scene, and still found residue of gasoline that was analyzed in the laboratory. What I'm saying my demonstration is that I poured a minuscule amount of gasoline on the ground and then didn't direct stream that thing so it would be spread around. It was not lightly put on. It was in a fog spray, it wasn't fog, but it's wide little pellets like when you're in your shower. And then we let it sit for a while and wet and still get the gasoline. But I'm saying in the real world, I've done that also. You know, we know sometimes that there had to be something to accelerate a fire based on witness information, based on what we could see physically, and we have come up with a gasoline sample after going through all the debris.
Sometimes you don't, correct?
Sometimes you don't, correct.
And you would agree with me, obviously, that a fire hose is different pressure and different volume of water than that of your hose you use in your experiment, correct?
No, I used fire hose.
Oh, you used a fire hose.
I mean,
Maybe I was
first off, I had a fire truck of my own, but that was done, I believe, in Detroit. We did it with a bigger truck. I had a mini pumper.
That was not in a burned out house, correct?
No, but I have had the same experiences in a burned out house. And by the way, I can tell you the pressure, if you want to let me, it's usually 200 pounds per square inch is what we fight fires with. Can vary a little bit here and there, but it's a lot of pressure.
Thank you.
Yeah, just finally, whether you can find any remnants of gasoline depends on how good you do your excavation and how thorough it is.
Certainly we'd be part of it.
Okay. And any evidence you have of evidence samples for gasoline that Mr. Leroy took, there was no evidence of gasoline, right?
We didn't take any sample.
Okay. Thank you.
Jury, do you have questions of this witness? Okay, I see some coming in. Questions from the jury, sir? Are NFPA guidelines interpreted subjectively or absolutely?
Well, as I said, NFP guidelines total? I'm sorry.
It just says, are NFPA guidelines interpreted subjectively or absolutely?
Depends. Some are absolute and some, you know, are, they can't be used as a standard or a, you know, doctrine of how you do things. But if you, I think they're probably referring to 921 though, don't you think, or not? Does it say?
Yeah, it just says NFPA guidelines. My guess is the 921.
Yeah. So, no, 921 is a guide, but it is a guide that is supposed to be a subjective, not a subjective, an objective document that you take, because it talks about don't be subjective in a lot of the areas. I think some of we put on the screen. So, but it's not an absolute, it's not something you must do, but if you don't follow it, I can tell you that it won't be good for you in the end.
If you could answer this one with a yes or no, please.
Okay.
Do you have any personal connection with Linda Stermer or her family?
I do not.
Do you conduct all investigations remotely? If not, why?
Almost never remotely. I'm almost always at the scene conducting an investigation like Mr. Leroy does. Not too many other ways of doing it other than if you're going to be trying to assess somebody else's work.
Where was the electrical panel installed in the house?
Basement level along the south wall.
According to NFPA 921 regarding excavation and debris examination, the terms adequate, in quotes, and some, in quotes, were shown. Does the investigator determine what these terms include?
I'm not sure about the word some. I'd have to, see that paper again. But there's a lot of, an investigator is given some latitude about what he feels is necessary. But if you're going to make a definitive cause determination, you have to go above and beyond that adequate level to make sure that your determination is correct.
Thank you. In Leroy's photo of the rear of the house that you reviewed, More of the exterior is burned away on the north side of the bay window than the south side. If the fire started in the chimney chase, why would you get an asymmetrical burn pattern on the window area?
There's only one picture, I think, that was shown. I don't know in Mr. Leroy's, I don't think he showed any other ones. But the dash cam from the sheriff's department, first arriving sheriff, you can see that the wind was coming out of the southwest, going across the house to the northeast. That's the explanation. Well, ventilation and fire suppression also.
How common is it for you to be called to review a case done by someone who was an expert in their field? Common's
Kind of a common word. I guess if I took percentages of how many fires I do and do somebody else's, do a technical review as opposed to my own, it would be slight.
Having not been to the house yourself right after the fire, did you at any point talk with Mr. Leroy to review any part of his investigation, to ask why or how he came to any conclusions? If not, why not?
Okay, I relied on his report and other information that he gathered. Normally speaking, we don't communicate, although we had the federal evidentiary hearing, we may have spoken a little bit, but it really wouldn't have been getting into the meat of the matter of the fire. It would be what he reported and what he testified to and what I testified to.
You stated there are 2 editions of NFPA 921, one published in 1992 and one in 2024. Are there procedures and codes in the 2024 edition that are not in the 1992 edition?
I wish I'd have brought both of them in. They're in my car. The 921 today is this thick. The 921 in 1992 was 1/5 of the dimension of this book. But I didn't mean to confuse you. These are not the only 2. They're published and printed almost every 3 years. The first one in 92, then there was one in 95, 98, 2001, 2005, then 2008, then 2011, 2014, 17, 21, and then this book. Each one of them, became more refined, had more information for us to have a better knowledge base. A lot of the book really doesn't have a direct relationship to what Mr. Leroy and I do, but it's something we should know about and how to proceed from there. More about electrical and mechanical, and they've added more about wildland fires, seaboard vessels, big, not just a boat, but watercraft, I guess, put it that way.
Okay, so there are some differences?
Yes.
Okay.
Yes.
And which edition are you quoting from today in regards to fire investigation, procedure, and regulations?
Everything is from the 2024 version because it's not a standard. If it was a standard or a code, you would rely on the code or standard of that moment. But this is never, by the volume, you can see it's ever changing or ever more additions. And today I need to be testifying to what was in 2024.
Is the 2024 edition of the NFP 921 relevant to analyze information, data collection, and excavation from 2007?
Yes, it expands upon it, and what was done in 2007 might not have all of the different things that need to be done now, but we are now in time frame, and if I may have testified to less than this book naturally because there wasn't this big book in 2007, but I would be responsible for what happened in the interim, how much more knowledge we have, our knowledge base is greater, So I would have to testify to what we have now, even critiquing my own investigation from 2007.
If you believe the fire may have started in the fireplace chase, then how do you explain how the fire made it to the victim recliner in the manner depicted by defendant?
If the chase is compromised and there was no barrier between the chase and the living room, there could have been a great deal of falling debris coming down on top of him. His hands were burned like this, as though he was stopping himself from whatever was happening.
He can't testify to the position of the...
I'll sustain as to the
Okay.
position of him. We'll move on to the next question. How do you explain the victim burns on body but sweatpants seem unharmed?
Okay, that's a pretty easy one for me. But your body can only take temperatures from 110 degrees Fahrenheit and up. Pants, clothing items, I don't know if any of you have heard of them. There's two movies, one remake, Fahrenheit 451. That is the basic lowest temperature that combustible clothing materials and other materials will actually ignite. So well, I can't get into that. That's the reason. Is he's not burned. I mean, the pants aren't burned. He's burned because he could only take the 110, and he could only take it for a short time. I would say that because of convected and radiated heat transfer, I'll give you another example. The sun is radiated heat. If we stay too long in the sun, our clothes won't burn, but we will. You know, we're going to feel that heat, especially when it's exposed, but even if it's protected by the clothing. But that was one of the big reasons why there was no way, well, can't get into that.
Okay.
That we can leave it at that. Skin and body burn much quicker or get degraded because of a lower temperature exposure.
Thank you. Counsel, any questions in light of the jury questions and answers, Mr. Blair or Mr. Mueller?
Yes, thank you. I'm going to go backwards because it's freshest in my mind. This idea of skin burning but the clothes didn't burn. Does NFPA 921 speak to that?
They do, or it does.
Do you have a section on that you can tell us about?
Not sure if I have that section marked anymore. I might have taken it out, but I'll find it.
How about section 24.2.5? And 24.2.5.1. How about we go there?
Okay. Okay, I do need glasses, I think.
You want my pair?
I got it. I was just looking, and a 7 looked like a 5 or something to me. But yeah, it's on the top of the page. Yes. I got it.
22.4, all right, 24.2.5.
24.2.5, yes.
All right, what does that tell us skin burns at? Thermal burns begin.
Wasn't the section I thought it was going to, but let me see. Maybe I need better light. This
That
talks
section,
about,
does that section, do we have a section that tells us thermal burns begin at 110 degrees?
we do, but I don't see it here. This is more about kilowatts and.
I might have the wrong section, but you do know NFPA 921 talks about skin burns.
It's in the book. It should be in this section, I think.
Do you remember what Dr. Markey said the burns, how he described the burns as thermal burns?
Yes,
Okay. And then does NFPA 921 also tell us that heat can be transferred through clothing, causing burns to the underlying skin without any readily identifiable damage to the clothing?
yes. Well, I've seen that firsthand many times.
And why is that?
Because of the ignition temperature, the temperature of burning for the clothing materials at 450-degree level, as opposed to your skin at 110 and a small amount above.
There's a picture that's up on the screen. I think it was addressing a question about some damage more to the north side of these bay windows, which would be the left,
Yes,
right? And then you mentioned a photograph from the in-car video.
yes,
Does that show the wind blowing toward the north?
yes.
Okay. Would that help account for the fact that you may have more damage to the north side?
Absolutely.
And with regard to one, you said NFPA 921 changes about every 3 years.
Yes,
It's
it's
updated.
supposed to be consistent every 3 years. I can tell you that I was on technical committees, and I'm not on now. I get no more time, but hopefully I have a lot more time. I didn't mean it that way. Once this goes into print and comes out, the technical committees are already working on anything else that's new and advanced. And then there's the technical committee, like the judge, takes these things and looks at them, and then if they're valid, or I would say any of your questions are invalid, but questions that really make an impact for a newer section in the book or even a sentence, that will be put in, and then it's voted on by all NFPA members at the
Okay.
end.
Mr. Trinkle, some questions addressed 2007's version and what might have been in effect then versus 2024. We are here in a 2025 trial. You as an expert, and any expert has to be open to change, right?
Absolutely.
So what standard or what guidelines NFPA 921 apply to this trial and this criminal case in 2025?
That would be the 2024 edition.
And just with respect to the various guides, if you're not open to change, what is that evidence of?
Can't be stagnant. You always got to be moving forward and learning every day. I learn something every day. Sometimes it's irrelevant, but like stepping on a Lego coming out of my bed. in the wrong
I
foot.
have a question.
Yes.
There was a question regarding are some of the guidelines absolute or subjective? You remember that?
Yes.
The scientific method has been in effect since 1992 and before.
Yes.
Right. That has to be complied with.
Well, the caveat is it has to be utilized and complied with unless you can absolutely say you did something equivalent and it comes out to the same thing. Just trying to get to what caused the fire. But normally speaking, if you said you didn't do this, they wouldn't even allow you to testify in most courts.
Certainly, Mr. Leroy was subject to scientific method in 2007, just as he is today, just as you are.
Yes.
And you have an opinion, you said, as to whether he complied or not with the scientific method, and that was?
No.
Okay. And the excavation principles in NFPA 921 are the same now as they were back way before 2007, right?
Yes.
So the fact that he didn't do what he told the jury he did, that would be in effect, you're held to those same standards.
Yes, you are.
So many questions. Okay. I don't have any other questions. Thank you, Mr. Trinkle. Let me get my.
Yes. Thank you.
You, I think you've even testified that to this here in court today. You don't agree with all portions of NFPA 921, correct?
Some I get revised, and people like Mr. Leroy and myself would look at them and ask, or put a suggestion in, like the jury box, to make a change. I've had some times where the computer section was new, and the second edition that came out, I think it's 2005 and 2008, one of them said this is, and it was wrong. It was, a typo, but a big typo. And so then they put in now is not, but they left them both in.
Well, but I think you've even testified this here in court. You don't agree with some of the information or the way they define things in NFPA 921, correct?
I guess define, you have to explain what definitions you're talking about.
I think we talked about you used ignitable liquid.
Oh, yes, I don't like that, yes.
You don't like that,
I
correct?
do not, because I have to explain to a jury that liquid doesn't ignite. It takes me more time to get to the point of fact.
And NFPA 921 is not an absolute, correct?
Correct.
It is, there's no requirement that you follow it, correct?
Requirement.
Legal requirement.
I guess there is no legal requirement.
And I think you testified to this in 2007, there were less requirements or less guidance, I think, in the 2007 edition than there was in the current editions of NFPA.
Yes, the 2007 would be somewhere halfway between these two. Each volume from the 92 version, which was very thin, the 2007 version increased in size and what was covered. And as I say, every year every edition, I've never seen it get smaller.
So I guess at the time in 2007, a fire investigator would have only had the guidance that the 2007 edition would have been providing, correct?
That guidance from the book, yes.
And would have only had then that guidance when conducting their investigation, writing their reports, so on and so forth, correct?
Right. We don't carry the book with us.
Because you would agree with me that looking back at something from today's standards to 2007, that's kind of reviewing something in hindsight, correct?
Yes, but like I said, I would review my own now and probably criticize it in a critique of what I didn't do the times before, but it wouldn't be critical.
But at the time, it may have been completely appropriate.
Completely appropriate. I'd have to know what you're talking about. It
Well,
was
sure.
a particular thing.
Well, you were just talking about looking back and even second-guessing yourself or reviewing yourself, right?
Sure.
So, but what I guess what I'm getting at then is, if you're looking back and finding things you may have done wrong in, 15 years ago, it didn't make them wrong at the time, correct?
It all depends what you did wrong. If you called a fire something that you couldn't prove, and now you find out that you can prove it or disprove it, as you mentioned before, yeah, those are variables I can't really address.
Now, when a fire goes up, it actually hits a roof and spreads out, does it not?
It hits, let's take this room for example, yes, fire starts on the floor level, continues to burn upward and outward, depending on the configuration of the room, configuration of the fire load, but eventually it hits a barrier like a horizontal surface, then it spreads out.
So, for instance, in the pictures we've looked at then, I think this is based on one of the juror questions, if the fire had gone up, it should have hit the roof and then spread to all areas of the roof in the Stermer residence, correct?
Way beyond what is the questions from the jury.
I think that's right in line with the juror question.
Oh, I'll let you ask, but I'll alert both of you. This witness has been on the stand since yesterday, so if you have any great questions, I'd suggest that you ask them now.
I think that's right in line, I'm sorry.
Thank you.
Could you please rephrase? I don't want to
Sure.
say something wrong.
If the fire had gone straight up and hit the roof and then spread out, like you've talked about what they do, it should have spread to all areas of the roof in the Stermer house, correct?
I don't think it's going to hit the roof. It's going to hit the ceiling of the cathedral ceiling, which isn't the roof. It's not right there. You've got probably scissor trusses or something to separate the ceiling of the cathedral ceiling from the roof, and it's going to spread from there first, and it's going to, as I said, heat and smoke, fire, rise, but they rise in a conical shape. It's not like this is three-dimensional stuff. Wherever the fire starts, say where Mr. Leroy is sitting, it's going to go in all directions around him and up until it meets that resistance, but that resistance is part of the house, not the roof.
Just a moment, Your Honor. Questions, Your Honor? Thank you.
I think you're limited to great questions.
Yeah, brief, great question.
You were just asking questions about complying, excavation, documentation. Those were absolutely required in 2007, just as they are now, right?
That's correct.
And that is ingrained in fire experts from the time they start training, right?
Yes.
You remember you were asked questions about, I'm going to call it, I forgot what Mr. Blair called it, playing devil's advocate with yourself. How could I be wrong?
Yes.
Right? And that's something that every fire investigator should do throughout their investigation.
Yes.
Do you have any evidence that Mr. Leroy played devil's advocate with himself on any part of his
Your Honor,
report?
that calls for speculation.
Do you have
Sustained
evidence?
speculation.
Okay. Is there a requirement in 921, back in 2007 and now, to be truthful and candid in your documents and reporting?
I'm going to object, Your Honor. I think that exceeds the scope of these jury calls.
Sustained cumulative.
Okay. Then I don't have any other questions. Thank you.
Thank you.
Jury, any others in light of the questions and dialogue? No? May this witness be excused from subpoena if he's under one, counsel?
No objection.
Yes, I don't think it's under.
Okay. Thank you, sir. You're all done. You want me to take this trash to discard?
Yes.
I can do that.
I'm going to find out where that is.
Oh, is this the gray pant, the sweatpants that have been admitted?
That's an exhibit.
Oh, okay. Okay. What, was that admitted? Oh, okay.
That's my binder.
Was that admitted? No.
No, that's my,
Okay.
I just referred into
Okay.
it.
So, Mr. Mueller, Mr. Kelly, any other witnesses? Any other witnesses?
Yes.
Okay. You may call your next witness. Sir, you can come forward. If you pause briefly. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And once you're settled in, we'll have you tell us your full name and spell the last, please.
My name is Mariusz Ziejewski, Ziejewski.
Thank you. Mr. Mueller?
Thank you. Sir, can you tell us what you do for a profession?
I'm a university professor at North Dakota State University.
And what is your specialty, or what do you specialize in?
My specialty is impact biomechanics.
What is that?
Well, that's application of physics, engineering principles in the study of forces on human body and effect of those forces on human body.
Okay. Can you give us an idea of the education you have that brings you to court today?
Well, my highest scientific academic degree is PhD, doctorate degree in engineering from North Dakota State University. I graduated in 1985. I have 2 Bachelor of Science degrees and 1 master's degree. All those degrees are from my native country, Poland. One of my Bachelor's of Science degrees are in mechanical engineering, and I'm diplomat engineer from Europe. It has equivalent standing to PE, professional engineer's license in this country. My Master of Science is in bioengineering, or equivalent to bioengineering. My other BS degree is in life sciences. Then I became university professor in Poland and worked on my doctorate degree in Poland. And I was invited on a research exchange program between professors from Poland and the United States. And back in 1980, I came to North Dakota State University. I quit my doctorate degree in Poland and started at North Dakota State as a part of my research exchange program, and graduated in 1985, became for 1 year lecturer, assistant professor, associate professor, tenure associate, full professor, and now I am professor emeritus.
Does that mean you're semi-retired?
Not really. I mean, I could, but no. But really means that it's a title. We can essentially do what we want to do. My choice is to continue work on the research. I have 2 PhD students. I don't teach.
What kind of research do you do, and how would it relate to injury causation that you're here for?
My research is in human brain modeling, mathematical modeling of human brain. In other words, how external forces affect human brain. I've been working on this project for the last 30 years. The primary sponsor for this project, research sponsor, was Department of Defense.
And specifically, who are you working with? What types of folks do you work with?
Well, it started in early 90s, National Highway Traffic Safety Administration. It is part of our government, civilian government, U.S. Department of Transportation. I worked from 1992 to 1996, 97 on mathematical modeling of human brain. NHTSA, for short, used this program that I developed in the study of real-life car crashes to understand the effect of head strike into the A-pillar. A-pillar is the connection between windshield and side window. 1996, I was invited to join Armstrong Aerospace Medical Research Laboratory. This laboratory is part of the United States Air Force at the Wright-Patterson Air Force Base in Dayton, Ohio. Back then, in 1996, women received all the rights that men had, and the question was how the safety system of ejection seat perform for female. Body dynamics for female is different than for male. In the scope of this work that lasted about 15 years, I was involved in analysis of 900 full-scale tests with male and female pilots. In 2007, now remember Afghanistan war, a lot of traumatic brain injury cases, and unfortunately many of our soldiers were released to civilian life with a clean bill of health, and actually they had the brain injury. So Congress appropriated over $100 million to Department of Defense to study that issue. And I was fortunate enough to be invited as a scientific consultant into that endeavor. And part of that work, I had $1 million research grant. I chair a number of different committees that relate to biomechanics of traumatic brain injury.
Okay. You have taught not only in engineering school, but you've taught in medical school. Tell us about that.
That's correct. I'm an adjunct associate professor at the medical neuroscience department, different university, 70 miles north from Fargo, University of North Dakota. I'm not a physician, so I don't teach medicine, but I teach how injury occur. So I was involved in teaching team-taught courses and obviously teaching the mechanism of trauma. In addition to it, I was involved in a research project, the School of Medicine and local emergency room, and the objective was to apply knowledge that we have in automotive field, in military field, to medicine, into emergency room. Completely different fields, and medical students do not know much about what we know in biomechanics. Obviously, we don't diagnose injury. We identify risk factors. We identify likelihood of type of injury. Physicians do what they're supposed to do, diagnose and treat injuries.
Can we kind of, put a bow around your background as injury mechanics, what causes injuries, the forces that are involved in injuries?
Yes, that's what it is.
You've lectured, I'm sure, before,
Yes.
around the world?
Well, yes. No, first of all, at North Dakota State University for 35 years, altogether as a professor for 40 years. But outside lectures, yes, at many different conferences throughout the world.
This is not the first time you've been in court in litigation, right?
That's correct.
Okay. You have been qualified as an expert in injury biomechanics. Give us an idea how many times.
I testified probably at least 80 trial cases since year 2000.
Around the country?
Yes,
Federal and state courts?
yes.
Okay. Your Honor, at this point, I'd like to move for the admission of Dr. Chesky, I'm going to butcher it, CV, and for his admission as an expert witness in injury mechanics, biomechanics.
No.
I will receive his testimony as an expert in injury. You said injury biomechanics?
Thank you.
Okay.
Doctor, can you tell us, in this case, you and I got together a few years back, what was your assignment, as you understood it?
Well, I was asked really two questions. First question I was asked whether or not from biomechanical perspective I can assess severity of trauma that this particular individual sustained. And the second question was whether or not we can determine how fast the vehicle, the Ford, was traveling at the time of the contact with the individual.
Okay. Now, you weren't talking about burn injuries here. You were talking about I'm going to call them orthopedic injuries.
Right. I talk about blunt injuries. I don't talk about the terminal injuries.
Okay. What did you review to be able to arrive at your opinion, sir?
Well, the most important for me was the medical records, the autopsy records. The medical description of the injuries were the most important. I also had the information about the type of vehicle it was involved. I received photographs photographs of the wounds and photographs of the vehicle with the blood on the carriage.
Okay. You reviewed the autopsy and medical records. I'd like to show you, prepared a PowerPoint. I don't know if you have it, but I'm just going to show you a slide from your PowerPoint. You can tell me if this helps illustrate your testimony.
Okay.
May I put it on? Is that a slide you prepared?
Yes, I did.
And what does it describe?
Essentially, it is verbatim statements from the autopsy record. As a biomechanical engineer, I'm historian as far as the injuries are concerned. I accept the injuries as diagnosed by physicians and present in medical records.
Okay. Does that help illustrate some of your testimony regarding Mr. Stermer's trauma injuries, forced trauma injuries?
Yes, my opinions are based on medical records because those are the objective evidence, forensic evidence in this case. So in the majority of my cases, I start with medical records as objective records and formulate opinion.
Okay. Your Honor, at this time I'd move for the admission of defendant's exhibit V. Victor.
Is it just the slide?
Just a slide.
Just the slide. I have no objection to just the slide.
Thank you.
What'd you say? V?
Victor.
Victor? V.
I'm going to show what we marked. Is that the slide you were talking about?
Yes.
Okay. Shows Todd Stermer, who at the time was age 42, 5'7", 180.
That's correct.
And I'll blow this up a little bit and see if we can describe some of the injuries, and you can explain what these injuries mean to us.
Well, and maybe I can give you numbers, because really that's so small that I know what is on it. I have a hard time to read
All right.
it, you know.
Just tell us what the injuries are.
If you go to those are the injuries, and the first three injuries relate to burn. I really don't deal with that, but I include it in the analysis. If you go to number 4, if you go to item number 4.
Give me a second.
Very good. We have 4 lacerations on the skull. So we have evidence of 4 separate contacts to the head.
Okay. Then
And
what?
the next one, if I can lead that, go to number 5.
Okay.
Okay. Minimally depressed marks, defects of the outer table of the skull underlying 2 of the lacerations.
Let's break that down. What is a depressed mark or defect? And then I'll ask you, what is the outer table of the skull? What are we talking about?
Skull is like a sandwich. We have a dense layer at the top and dense layer at the bottom, and we have this porous layer in the middle. This description indicates that only top portion of the dense layer of the skull was, as was described, depressed. Normally, if you have a linear fracture, you have a linear fracture all the way through the skull. It didn't happen. It just simply top portion was compressed. Now, it is important that that type of description relates to 2 lacerations. So already we are connecting the 2 lacerations to one event that is quite similar in nature. I mean, the chances are that you might have a very similar outcome from completely 2 independent blows. It can happen. But clearly, this will be more consistent with head contacting something that is on one side and another side. There's a rigid object in one motion, head motion, with respect to the rigid structure, created those laceration and minimally depressed skull.
In 2 spots.
2 spots.
Okay. What else?
And now what I would like you to maybe skip to go to number 7.
All right.
Okay, so now we have a depression of outer area of the left parietal bone of the skull.
What's the parietal bone?
Side bone. If you look at the midline to the temporal area, this is parietal bone. So we have depressed area in that location. It's on the left. Now, if you go to number 10, now you have a depressed mark on the outer table of right parietal bone, underlying laceration. So what is important that we have in both areas, left and right, we have an outer area of the bone. So now we know that the 2 areas that the records refer to are on the side of the head. The size is somewhat different. The one on the right is about ½ an inch, the one on the left 1/4. That's not that critically important. Important thing is that the nature of the damage is the same left and right. So both of those happen from one particular event.
Okay. What else do we have?
Now I would like you to go to item number 8. Okay. V-shaped laceration in a midline, posterior, frontal/anterior parietal scalp over the vortex of the skull. A lot of words, but midline is midline of the head. Posterior is the back. Well, the word frontal tells you is front /anterior because anterior really means front. Parietal scalp over the vortex of skull. So there's some laceration close to the vortex area. Remember, we have 4 lacerations. We explained 2. Now we are dealing with the 3rd one on the vortex.
Where are these words coming from?
Directly from, by the way, notice that after each sentence, I have a parenthesis, document 1:17. That's document 1 in my list of material studies. That's the autopsy record. And :17, that's page 17. In addition to it, I attach the date for this diagnosis, 1/8/7.
Date of the autopsy.
That's correct.
Okay. Where are we going next?
And the last one really would be number 11. And again, talks about this 2.5 inch gaping linear laceration on posterior back midline region of parietal occipital scalp. Now, occipital scalp is the backbone of the head. So now we have evidence of contact that extends from the vortex to the back. And those are 2 separate lacerations as identified, and we have 2 on the side, we have 4 lacerations.
Okay. Anything else we need to see there?
No, those are the most important aspect to us because lacerations are AIS level 1. AIS stands for Abbreviated Injury Scale. It's a trauma scale that we use in civilian and military organization to link diagnoses to engineering parameters. Now we want to medical field and engineering field to communicate. And AIS scale allows us to do that. Based on AIS scale, we can use the evidence of the injury, and we have an engineering component attached to different level of AIS scale. Essentially, AIS scale is fatality scale. AIS level 1, 0 fatality. So all the lacerations that you see, the likelihood of fatality from it is 0. The next level, AIS level 1, is linear skull fracture. We don't even have linear fracture.
What is a linear fracture?
Well, linear fracture versus depressed fracture. Linear fracture, the skull get hit and fracture. You have a line, fracture line for the skull. Depressed fracture, when you have additional energy that causes comminuted or complex fracture of the skull. Here we don't even have linear fracture because it doesn't go all the way through the skull. But still, I would assign AIS level 2 score according to the scale because there is portion of the skull that is fractured. And probability of fatality is very low. The survival rate is 99.2%. So 99.2% likelihood of survival from this kind of injury.
And tell us, were there any brain injuries involved here?
There's no indication of the brain injury. In other words, the bone heals, and they very often there's no residual effects. The problem is that we have a soft tissue that might not heal. So in terms of the brain head injury, we are very much interested in what happened to the brain. There's no bleeding in the brain. There's no contusions or bruising. Contusions is bruising that happens if you get hit in the head and brain strikes the internal surface of the skull, it might bruise. Bleeding can occur. No laceration. So there's nothing in the brain tissue that was identified as evidence of trauma.
And the AIS-2 level would be considered what? How would you describe that level?
It's called moderate. You don't have evidence of internal brain trauma, and level of survival is 99.2%.
And in this particular case, you had pictures of the undercarriage of the van, and it tested positive for Todd Stermer's blood. Do you have an opinion, doctor, whether all the injuries that he suffered, all these traumatic injuries, other than the rib fractures, dealt with contact from the van?
Yes, everything is consistent.
I don't think you can opine on that. I think you can say those injuries are consistent or not, but we're outside of the scope here of what he could testify to.
I'm allowed to ask if it's consistent with. I
Thank
think
you.
that's appropriate.
Are they consistent with a single event?
They're consistent with single event, the interaction between his head and the pickup going in opposite direction.
Okay. Do you have a slide or a photograph that depicts the injuries to the skull and then also the components of the undercarriage?
Yes, I do.
Okay. Your Honor, just to advise, there's just going to be one picture of the skull from the autopsy. showing some lacerations. And counsel has that.
Yeah, as long as it's just the one slide in the report, yes. That was right above the one we've already admitted.
I believe that's Exhibit
Figure 1.
Q. Okay. Move for the admission of Exhibit Q.
And you? Yep, we have a
Oh.
queue. That was this morning.
Figure 1. Oh, U, I'm sorry, U. Sorry. Thank you, Ms. Heidi.
And jury, it sounds like there might be a little graphic here, but bear with us. We'll get it on and off the screen.
Thank you.
Mr. Mueller?
Doctor, can you show us,
Yes, I'm admitting you.
good? Can you show us what you're talking about in terms of injuries and tying it into the injuries of the skull?
Can we focus on the top left corner of this composite? And I prepared this composite. Right. So we are looking at the top of the head. The nose is up to the ceiling. And at first, let's look at the two lacerations from the side. Those are the two lacerations that we discussed initially.
This
then
one
we
here?
have the big laceration, and there are some small fractures, outer layer of the skull. And then we have a laceration on the midline in the vortex. That's the laceration. And if you look at the laceration to the vortex, the force applied was obviously into the head and backwards. So the vehicle was going backwards, so his head was moving forward to end up with this kind of
Relatively.
injury. Relatively.
You understood that all the blood was on the front surface of the undercarriage components.
That's what I understand.
So what does that tell us in terms of any of these other pictures that you're talking about on this?
Well, what is really is telling us that from biomechanical perspective, I see one event, this individual with the head orientation into the front bumper of the pickup, and the pickup going over his head, and those injury took place.
Okay. Getting back to that first opinion about a single event, is your opinion, having read Dr. Markey's testimony and his autopsy, is your opinion consistent with his that none of these injuries were fatal?
That's correct. I am.
Then let's talk about what type of impact. When we talk about forces, we're talking about loads, right?
Yes.
Loads in your business.
Yes.
All right. Tell us, do you have an opinion, given all the material you've reviewed, whether or not these injuries are consistent with a low-speed impact of the vehicle?
It is. Actually, cadaver studies show that head striking a rigid surface at 5 miles an hour, it's like 7 feet per second, it's like slow jogging speed, is sufficient to cause linear fracture. And the forces that were measured was 1,500 pounds, 5 miles an hour impact against a rigid surface.
So what does that mean in terms of, are we talking about low speed, high load?
Yes, I mean, low speed, 5 miles an hour is not the high speed. And if the impact happened, I guess not the right way, the wrong way, skull fracture can occur at that velocity.
But here it didn't.
It did happen. We have some minor fractures, which I would not, again, classify as linear fracture, somewhat less than linear fracture. So less than 5 miles an hour.
Do you have an opinion based on your review of the photographs, the medical records, the injuries, in terms of the relative height of Todd Stermer's body as to the vehicle on impact?
Well, the only thing I can talk to you about is where the head was. So the head to be somewhere at the height of the bumper or somewhere below, because they had to go under the carriage.
Finally, there's been some talk about the possibility of a frying pan being involved in this impact, in an impact. First of all, as a medical expert, do you deal in possibilities?
No, I don't. That's speculation.
In terms of your review of this case, do you have an opinion as to whether there is any evidence that suggests that a frying pan could have been involved in this trauma?
I don't see any evidence, because all the evidence that we have aligns very nicely in the sequence that I described to you. So on more likely than not basis, there was only one event, the interaction of his head with the undercarriage of the vehicle.
And can you describe any significance to, I think you said some symmetry between the lacerations?
It is. From very beginning, I mentioned to you the side fracture, position very symmetrical, pretty much the same extent of the fracture, meaning the same loads. So something there under the pickup, how it's designed, that there were two edges of sword that came in contact with his head in those two locations. And then there was less severe, there was the contact with the midline from the vertex to the back of the head.
Okay. Your Honor, just give me 1 second. Doctor, thank you for coming here from Fargo. No more questions at this time, Your Honor.
Ms. Ziderbean, any cross?
Yes, thank you, Your Honor. Good afternoon, Doctor.
Good afternoon.
So I just want to be clear, you study the force that an injury, what force it takes to cause an injury on a skull.
That's correct.
In lay people's terms.
That's very well described.
Okay. You're not a doctor of medicine.
Right, I'm a doctor of medicine.
You're not a forensic pathologist.
That's correct.
And you're not here to opine about injury patterns or that sort of thing on a body at autopsy.
No, actually, injury pattern is part of biomechanical evaluation, because we are talking about the forces. And we are very much interested in the pattern, because lack of pattern creates additional body kinematics, additional body motion. We are interested in that. So symmetrical pattern obviously tells us not much rotation either way, just uniform body position. So pattern is actually part of the geometry, part of physics. Not the physicians do not understand what pattern is. We all understand.
So I'm going to stop you there. You're talking about patterns of maybe where lacerations are?
Correct.
So you're not looking at like a pattern, like if somebody were to be hit with something with dots on it, that it would cause a pattern on their skin.
No,
We're not talking about that, right?
No, I do, or we do, because the type of imprint, you have a silly part, you put the finger, and somebody will ask us what caused this imprint. It's important that we will be able to figure out it was a human finger that left the imprint. So no, we are very much interested in the geometry of trauma.
Okay.
We are.
But looking at this, we're just looking at lacerations and where they're located on the skull.
Okay.
Lacerations, nature of lacerations, location of lacerations. More than that, the type of evidence of the skull fracture. Both sides we have just the top layer of the skull. What the chances are that random two forces come striking the head and only top layer of the skull is fractured, not all the way through or not at all. Well, the situation is very simple. It's some kind of symmetrical orientation and will give you the same amount of force and approximately the same amount of depressed fracture. There are some small differences. One is a quarter inch, another was is half an inch, minor difference.
So when you're talking about the depressions, you're talking about depressions into the bone.
Yes.
And it could certainly be possible for there to be depressions in the skull created by different impacts.
Theoretically, yes, anything can cause, if it is forceful enough, to cause depression in the skull, sure.
Yeah. So each one of those could have possibly been caused by a different blow or a different trauma.
I don't deal with the possibility on more likely than not basis, no. Everything is so symmetrical. I cannot envision two separate blows and give you pretty much the same type of laceration and top of the skull fracture. That's so unusual. Typically you have no skull fracture or fracture all the way through. So somewhere in the process, the force ended.
So doctor, I just want to stop you there. You have the two that you're saying are symmetrical, but you also have one on the top and one on the back, correct?
There's no fracture, there are just lacerations.
And indentations?
Indentation, yes.
Okay, okay. And so all of those are then what we would classify as blunt force trauma?
Yes.
Okay. And I was taking a look at your report, and I think you testified as to what you reviewed, and it included the autopsy report, the car specifications, the trial testimony of Dr. Markey, and the photographs. Are those the photographs of the autopsy?
Yes, and you saw also some photographs of the undercarriage of the vehicle.
Okay. So you didn't review any of the testimony that any of the witnesses have provided?
No.
Okay. And a blunt force trauma to the head, if somebody were to hit a skull, a human skull, with an object, would you expect to see the same sort of indentation or laceration?
Sure, you can hit the skull any place, and you can get a laceration, an indentation, a skull fracture. Sure, it can happen.
And so basically what you're looking at is the amount of force that it would take to cause these lacerations, and you're concluding that they're not fatal.
Correct.
You're not here to talk about any of his other injuries.
No, just based on skull and lack of brain injury. If there will be any bleeding, contusions, laceration, you will hear me talking about that. And that injury will have a higher AIS score than skull.
So you are aware, after reviewing the photos, or are you aware that there were actually several different spots where there was blood underneath the van?
Yes.
More than 4?
Yes.
And are you aware there were multiple injuries that were seen not just on the head, but also on the body?
Yes, if you look at the medical records, I list some of them: arms, thoracic, rib fractures, and so on. Extremities, yes, but those are of minor significance in terms of the fatality.
In terms of the fatality. But we can agree that there's definitely more injury than just on the skull.
Yes.
And we can agree that there are multiple points underneath the van.
Yes.
And you can't say what part of Todd's body touched what part of the van.
No.
Because that would be speculation, right?
No, I would probably, if I will have exemplar van and three-dimensional model of the skull, I bet we could go there and match what portion of the undercarriage create those two imprints. Lacerations, they'll be more difficult, but if you already have a one point identifying the indentation to the side, you're in a good shape to identify where the head was and probably find the location for lacerations. But no, I didn't do that.
Well, and there, we can agree there's more than one laceration. So you'd have to match where the laceration on the back came from, the laceration on the side, the laceration on the arms. You can't do that. That's not what you're here to do today.
It didn't do any other lacerations except the head, but the fracture on the side and laceration goes together. And then you have a impact to the top, and then flexion of the neck, and you have a continuation to the back. Although there was no injury to the neck.
So I'm going to ask you that question again because I don't think you answered it.
Okay.
You're not here to match.
Yes, that's fine.
You're not here to match the injuries that he sustained on his back, his side, his arms, to any particular portion. You've only analyzed the head.
That's correct.
And you can't say, sitting here today, if it would have come from a blow prior to being hit with the van, right?
That's correct.
And you can't say what particular blows on his head came from the van.
No, as far as the blows to the head,
Your Honor, it's not unresponsive. I just needed an answer. Thank you.
Are you moving on, or?
Yeah, I'd
Okay.
like to move on.
Okay.
Thank you. And I just want to be clear, you've reviewed no testimony from any other witnesses, and you've seen no testimony that was provided that somebody claimed that Todd Stermer was hit prior to being hit by the van with a blunt object.
correct. Didn't have not seen this testimony.
I have no further questions for this witness, Your Honor.
Miller?
Just a few more before I wrap up, Your Honor. You did account for in your findings other lacerations on his body, right?
Oh, I knew where they were. I identified this in the medical records, and some of them I listed in my summary.
Okay, if I go to number 14, you noted the laceration on the right rear shoulder and upper back,
Correct?
and the upper left arm,
Correct?
and the lateral back and chest. So you noted all those.
Yes, I did.
But they didn't have to do with anything having to do with your analysis of whether or not these injuries were serious enough to have any type of chance of being fatal.
Correct. It's AS, any lacerations, abrasions, AS level 1, 0, likelihood of fatality.
Your ultimate opinion, or one of the opinions you have, though, is given the nature of these lacerations, the symmetry, it's more likely than not that everything happened from a single event, all those head lacerations
Yes, the
And
head
fractures.
lacerations, yes.
and fractures.
And what?
And fractures.
Yes,
And they would have been from the van impact.
definitely.
Thank you. Anything else?
I just want to be clear. You said that the two on the side of the head were symmetrical. Those would have maybe come from one incident. But then I believe your testimony was that the other ones were not then associated to the two on the side.
It might be. I'm just saying that those two very much symmetrical, and then we have a top and extending to the back. I did not match with the exemplar vehicle, so I don't know if the structure, undercarriage structure, that will leave the side depression, also have close a surface consistent with the contact with the top. If it does, everything happened right there. If not, it happens somewhat later.
And that would address 3 out of the 4 lacerations.
No, because this laceration on the top, there's extension. Everything is the midline of the head, so it's extension to the back. Now we have 4.
I just wanted, the slide that was shown showed a laceration, and I'm just going to show you your slide, showed a laceration on the top of the head. That's the laceration we're talking about here, right? The one on the top.
Yes.
And so this photo doesn't show the laceration in the back.
This photo doesn't, because the head is laying on something, so it doesn't show the occipital laceration.
So the laceration on the head goes, for lack of better description, from ear to ear side.
No, go from extend, have certain width, and goes from the top to the back.
So what we're looking at in this photo that you put up on the screen, is this the face?
That's the face.
And this shows the injury going across the top of the head this way.
No, there's an impact and tissue bursts that way.
Okay.
So if you have a sphere and you hit material, you get a laceration perpendicular to the direction of the force. And some of the tissue will be pushed in the direction of the force. That's exactly what happened.
Okay. And then this does not show the laceration in the back of the head?
No.
Because the body is laying on its back?
Yes, but it's in medical records.
Okay. And you can't say where the blood came from on the van, like in the different areas in the photos you looked at?
No, I mean, other areas were bleeding. It could come from different areas. And remember, blood is splattered. It just goes in different directions. So sometimes it's difficult to pinpoint where exactly, what's the original source of the blood.
Especially if you have lacerations on your head, your arm, your back, and your side. Would you agree?
That's correct.
I have no further questions, Your Honor. Thank you.
To make sure we're clear, in your expert professional opinion, you saw no evidence that's consistent with impact from something like a frying pan, right?
That's correct.
Thank you.
Not.
Your Honor. I just want to clarify, you testified that you can't say that a blunt force object could not have caused one of the lacerations.
No, I said, in general sense, laceration can be caused by blunt object, period. Now, totality of the evidence, or more likely than not basis, how everything is lining up. That two contacts on the side, and one extended contact from the top back.
But the totality of the circumstances would also take into account testimony that the defendant said she hit him with an object. Would you agree with that?
And it goes way past the
One is, I'm going to sustain the objection as to foundation.
Did you take into account any of the testimony from the trial?
I was aware of this fact from reading trial testimony of physician, and on more likely than not basis, I don't see any evidence of that. I just see the evidence on the head from contact from undercarriage of the forehead.
But you can't say, from what your prior statement was, you can't say that another blunt force object did not cause one of those lacerations.
More likely than not basis, everything fits. contact with the undercarriage. That's
Unresponsive,
all.
Your Honor. It's unresponsive.
Responsive, he's answering the question.
Sir, if you could try to just, I think if you can answer it with a yes or no, if you could do that.
Is it possible
Oh.
that one of the lacerations was caused by a different source of a blunt object?
Possibility is speculation. Is it possible? Yes, you might have an impact and no trauma. Then we won't know that really happened.
Your Honor, it's unresponsive.
You said it is possible.
It's possible.
Thank you. I have no further questions.
Your Honor, you also said possibilities are speculation, right?
Yes, it is.
And do professional experts engage in speculation?
No.
Why not?
Well, because there's infinite number of possibility pretty much for everything that happens. So we are evaluating things from more likely than not basis. That's why we are evaluating the pattern. Everything fits in one particular motion. More likely than not, this is how it happened.
And one single event being the van impact?
Yes.
Thank you.
You can't line up those injuries to the parts of the van.
Objection, asked and answered.
I'll allow it. She's asking the exact parts of the van.
No, not specific parts. As I said, I did not match the specific geometry of the undercarriage.
Therefore, you're speculating about how these injuries occurred.
Absolutely not. Because I know the outcome. I see the blood in the undercarriage, so I know the body was there. And I see the type of trauma, laceration, and under laceration, I have some evidence of fracture. I can guarantee you that's a rigid object in some kind of rounded edge that came in contact. And we have a symmetry to it, consistent with similar structure of the undercarriage.
I have no further questions, Your Honor.
Thank you, Your Honor.
You good?
I'm all set. Well
Okay.
done.
Thank you, sir. Oh, I'm sorry, jury. They often have questions. Okay, I have some questions from the jury. In your biomechanical analysis of the injuries, are you assuming that the object being struck, namely the skull, was in a stationary state at the time of impact?
No, it doesn't have to be. The relative velocity has to be about 5 miles an hour. So it could be 2 miles an hour and 3 miles an hour. 2 miles an hour of the skull and 3 miles an hour of the pickup.
If so, could the severity and analysis of the injuries be altered if the object, the skull, was in motion either toward or away from the vehicle?
No, the severity is what it is. So the 5 miles an hour is sufficient to do that. And it could be skull going 3 miles an hour away, and then the pickup will have to be going 8 miles an hour into it. So the differential, 5 miles an hour.
Would you clarify the direction of travel of the van during the impact event?
The only thing I can tell you is the direction of the van with respect to the head. The head is pretty much directly into the bumper, a little bit under the bumper, and the van is coming over.
Did you computer model the impact event?
No, there's no reason to do a computer model because the evidence are so straightforward and based on the questions that I was asked. There was no need for that.
Based on your examination of the data, do you think Todd was laying face up or face down when hit by the van?
It was face down. We know that at the very end there's some medical observation about dirt in the nose and dirt and grass in the mouth. So definitely it was face down, but somewhat off the ground initially when the impact occurred, but facing down.
Okay, thank you, sir. Counsel, any questions in light of those questions and answers?
Thank you. That face down is based on your review of the medical records, the autopsy records, and the photographs of his face?
Yes.
Okay. 1 second. Would you agree, based on your biomechanical engineering background, that if all the blood spots are on the front side of the undercarriage components, it would mean that the van was going forward?
Yes.
Okay. And simply, when you're asked about the skull being stationary, absolutely still, versus there could be a relative movement of the skull with respect to the bumper.
Oh, the relative motion of the skull before the impact, I don't know. There's no evidence. So from physics perspective, I cannot tell you. I know that what was the orientation at the time of impact? Quite symmetrical. It could be some waving of the head before, but at the impact was quite symmetrical and vertical because of both lateral laceration and skull fractures are so symmetrical, so could not be tilted to an extent left or right.
But it was face down.
It was facing down because we have the side impact and then we have a top and the continuation to the back.
Thank you, Doctor. Appreciate it.
So, I'm sorry, I just want to make sure I clarify. So you're saying if somebody were moving away from the vehicle and the vehicle then was coming from behind, then it would be higher than 5 miles per hour?
The actual velocity of the vehicle would be higher if the body would be moving, let's say 2 miles an hour back, then it would be 7 miles an hour.
If the body were moving 5 miles an hour forward, then the vehicle would have then traveled faster.
If the body is moving 5 miles an hour forward, the vehicle could be stationary. And you have 5 mile an hour impact.
Well, the vehicle would not be stationary when they make impact.
I know, but I'm...
Unless the body ran into the vehicle, correct?
Right. That's the test. The 5 miles an hour test in skull fracture was done that way. The surface is stationary and the head hits the stationary rigid surface. So the relative velocity between the head and the impact surface has to be 5 miles an hour. It doesn't matter.
So if the object is going faster, then the vehicle would have to go faster in order to then create that 5 mile an hour.
You have to give me the direction because it depends what direction. But yes, the difference in the velocity, the vehicle has to be going 5 miles an hour faster in the same direction, right, in the direction of the skull to get the fracture.
I have no further questions, Your Honor. Thank you.
Well, I do. If the body was going 5 miles an hour, that you said is jogging speed, correct? You understand the facts of this incident is that Todd Stermer was likely on fire?
Correct.
And you would also expect lower body injuries if he was upright, wouldn't you?
Your Honor, I'm going to object. I don't think he's specialty will let him opine on that.
That's exactly in his wheelhouse based on the questions I received.
I will overrule that objection.
Thank you. Did you see any lower body injuries?
Well, the abrasions that we talked about, back and shoulders.
No
nose.
fractures, no nothing?
No.
Okay. You would expect if a body was running and got impacted with a van, you'd have to be, and let's do the quick math. For a change in velocity of 5 miles an hour, if the person's running away at 5 miles an hour, the vehicle would have to be at 10, wouldn't it?
Yes.
Right. You didn't see any evidence of that, did you?
No, there will be fractures in this now.
Thank you. Have a safe trip back to Fargo.
Thank you.
Jury, any other questions? May he be excused from his subpoena, counsel?
No subpoena, but he may
Okay.
be excused.
Okay, thank you, sir.
Thank you.
Counsel, can you approach, please?
Second.
A short break, hopefully, maybe, we'll make it your usual 15 minutes, and we'll go as late as close to 5 today. Okay, so at some point I'll want to sit down and go through those. Yeah, Joe usually types up kind of a. Okay, back on the record, People versus Linda Stermer. Any matters? Welcome back, jury. Mr. Mueller, you may call your next witness.
Greg Storm, to the stand, please.
Before you have a seat, if you raise your right hand, do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And once you're settled in, we'll have you give us your full name and spell the last, please.
Gregory James Stormzant, S-T-O-R-M-Z-A-N-D.
Sir, I'll have you move that microphone closer to your mouth so the jury can hear you. Thank you. Mr. Mueller?
Thank you, Your Honor. Good afternoon, Mr. Stormzan.
Afternoon.
Sir, can you tell us, what is it you do now for a living?
Retired.
Back in 2007 in January, what did you do for a living?
Back then, I was the Assist District Fire Investigator, which was out of Grand Rapids, Michigan.
Do you
the
folks at the
Michigan State
Michigan
Police.
State Police have different areas and districts that you cover?
Yes, sir.
You were actually a certified fire origin and cause expert?
Yes.
How long have you been doing that? At that time, 07?
At that time, I got in the State Police Fire Investigation in 1999. I completed their training in 2000, so it's from 2000.
Okay. Back in January 7, 2007, there was a fire at the Stermer residence in Lawrence, Michigan. Your name came up as being part of an investigation on January 8, 2007, the next day, with a man named Scott Leroy. Do you remember at all going to the Stermer house in Lawrence?
Just vaguely since then, yes.
At that time, if you were 2000 and Mr. Leroy was certified or became a fire inspector in 2001, wouldn't you have had seniority over him?
It's not much of seniority. I've been in the unit a little longer than he had. I was
Okay.
in, 99. His is 2001.
Would he have had jurisdiction over this fire because you folks work in districts or something?
Correct. Yes, it'd be his area of responsibility.
You were there then to assist Mr. Leroy?
That's correct.
Okay. Do you recall participating in any type of investigation at the scene?
Not specific investigation. He asked me to do a scene sketch of the residence, basically do the footprint, basically the outline of the house.
Okay, let me, if I can. May I approach, Your Honor? Thank you. Just going to show you something. Does that, in the upper right corner, can you just tell us what you're looking at, just to kind of jog your memory?
The upper right-hand corner would be the case number 04-18-07, the date, sketch not to scale.
But it's just GJS are your initials?
Yes.
All right, that's what you're talking about.
Okay, yeah, that would be my initials. That's how I know I did this one.
Do you recall the damage to the level of the house?
It was, recalling from the, thinking back, it was pretty severe, basically over the living room area of the house, which is on the main floor.
Okay, let me show you a photograph, and we can either look at it on the overhead or if it's easier for you, just on this blow up. But does that bring back, yeah, that looks like the house we did.
I'm going to object, I guess, it's the lack of foundation, Your Honor. I don't know that he's ever had this view of the house before.
He was there on January 8th with Mr. Leroy.
This has been admitted, yes, but my concern is a foundational issue with him testifying from this. I don't know that he was ever up in the air in this case.
Why don't you lay a foundation?
Sure, you were at the scene, correct?
Yes.
And did you even look in the house or walk in the house?
Yes, did a walk around, and to the best of my knowledge, I thought that to the best of my recollection that Scott led me through the house and a quick, walk around and say what happened and all the general description of what he saw.
Does that jog your memory as to that's the house we're talking about or no?
That appears to what the house that I remember looked like.
Okay. Did you take any photographs that day?
I don't recall taking any photographs.
Did you make any reports for your investigation?
I did not.
Other than these
Other
two
than that, I
sketches?
was asked to do the scene sketch, yes.
When you're doing a scene inspection, obviously this is considered a big loss, a lot of damage.
Mm-hmm.
Yes?
Yes, sorry.
Not every fire is the same. Some are kitchen fires, right?
Some are very small, yes.
All right. When you have, and especially, not that you treat anything else differently, but when you have a death case, it's a serious, serious case.
I'm going to object, Your Honor. I think the issue is we're not qualifying him as an expert in cause and origin. He sounds like he's testifying as a lay witness. Now we're asking him about how an investigation is conducted. I don't think that he's...
There are, again, I know there's a legal objection.
Are you objecting as to?
Oh, relevance and he's not an expert.
Okay.
He's not named as an expert. He's talking about his experience. He's even more experienced than Mr. Leroy, so he's talking about excavation, which is the heart of this case.
Well, I mean, I think it sounds like it's an expert question, so I'll sustain the objection.
In this case, do you recall participating in any type of excavation of this damage to this house?
No, I do not recall doing an excavation.
If you had been part of an excavation of the house, would you typically do a report given your experience and training?
I would, depending on if there's anything significant that we found in the incident, I would maybe do a supplemental report if requested by the senior, by the officer.
Certainly would be important to do an excavation in order to find something significant, right?
It can be, yes.
Okay. And despite you were in an assistant position back then, correct?
Yes, yes, sir.
You don't recall doing anything of the sort? Reports, photographs, anything?
No, sir.
Thank you. I don't have anything else.
Mr. Blair?
Good afternoon, Mr. Stormson.
Afternoon, sir.
What was your rank with Michigan State Police at the time?
Specialist sergeant,
Specialist Sergeant?
same as, Mr. Leroy at the time.
Okay. Mr. Mueller, do you want your iPad? Oh, you want your, you can hand it to you. I just don't know if you want to touch it or not.
Break your claw.
I'll make that kind of money. And so you were both specialist sergeants, correct?
Yes.
Sometimes referred to as detective sergeants?
Well, detective specialist sergeant, call us, technically my badge said specialist sergeant, so, yeah.
So you were both of equal rank.
Yes, sir.
And in the hierarchy of the Michigan State Police, there are sergeants, and then there's actually like a lieutenant above you guys that's the manager of everybody, correct?
Correct.
And so on the 8th of January, you were actually just called down as an assist to Mr. Leroy, correct?
That is correct.
And you were there to just kind of help him with whatever he might have needed help with, correct?
That is correct.
And would it be fair to say your memory of what you did that day is fuzzy?
Yes, sir.
Don't necessarily remember everything?
Correct.
And so when you say, when you're asked questions about an excavation, you don't specifically remember doing an excavation?
I don't specifically remember it. I thought we might have, but I don't specifically remember.
Okay, you thought you might have.
Yeah, but like, how could I answer that? Through the years, had so many fire investigations, we've worked with each other that they all get pretty foggy after the years.
And would you agree with me that it's pretty much state police protocol that whoever's like the lead on a case writes the report?
That is correct.
And that sometimes people that assist don't necessarily write supplemental reports?
Correct.
And would you agree with me that what you had on January 2007 was basically a fairly limited role at that scene?
Yes,
Do you
I would
recall?
say that.
Okay.
Done something significant as an excavation of a total loss that you wouldn't have written any report?
If I would have done an
If you
excavation,
would have even assisted and helped in doing a major excavation, you wouldn't have written a report to account for your
I
day?
might have, depending on what we found, or if nothing. Normally, lots of times, the senior investigator, the person writing the report, would put in, was assisted by so-and-so doing this, taking photographs, or whatever the specific request was done.
Okay. You would certainly expect a thorough report to be done, though, right?
Or,
Yeah, I didn't ask him that.
What's the objection?
Ask and answer.
I'll overrule that.
Go ahead. You would certainly expect a thorough report to be done.
or in the report, a section would be during the excavation, so-and-so, we found this or that.
All right.
Yes.
Not simply omitted.
Yeah.
Okay. Thank you, sir. Thank you for your time.
No.
Jury, do you have any questions of this witness? No questions. Excused from subpoena if he's under one?
Yep.
Yep.
I do
Sir,
have one subpoena.
Okay, sir, you're excused from subpoena. Thank you.
Thank you, sir. Now, as we approach.
You may.
Let me take the report.
Jury, after I said we'd run till close to 5, I'm going to let you go early today, so, and come back again tomorrow at 9 o'clock. Remember your instructions, no discussion of the case with anyone else, no media, no social media, investigations, research, anything of the sort. Counsel, the jury's left. Any matters to address?
No, Your Honor, I think we'll be here early to talk about jurors.
Your instructions, 8:15.
8:15 sounds great, Your Honor. Thank you.
Thank you, Ron.
Are we doing that in here or in chambers?
We can do it in chambers, so I'm just going to limit it to just lawyers, so it's not too crowded in there.
What are we doing?
Just limiting the, well, we can meet in my office for finals, to talk about finals tomorrow. What? Yeah, no, 2 lawyers on each side. Oh, okay. No, I'll let you both come in. Yeah, I just, yeah, okay.
The guys that speak to
You are in the meeting now.